listed on 7th this month. The IO personally appeared and the lordship kept it to 2 weeks after today. Inadvertently, it has been in the order sheet, it has been 21/8 instead of 21/7. Maybe listed day after tomorrow. That
if already there is an order, you have to move application for preponement. There is an order, it has gone on record, then unless you move an application, it can't be done. I have to modify that order. Move a formal application and mention it as immediately.
Tomorrow I will
move a formal application, I will just modify. Yes.
May I be pardoned, my lord?
Yes.
My lord, hearing number 93, subject to your lordship's convenience, I have filed the written notes. If it is taken 2 p.m. also,
Yes.
if it is not inconvenient to my learned friend appearing for state, 2
p.m. No problem.
Grateful.
Okay.
Well, it's item 22 of your lordship's board. When there are 4 vigilance matters, 19, 20, 21 and 22.
Yes.
I am mentioning about 22. Maybe taken up next Thursday. I need to reconstitute the entire record. It has been
22 next Thursday.
Next Thursday.
And what about the other matter?
I am ready. 19,
22 is 2011 matter.
Yes.
And 19
18,
is
19, and 19, 20 and 21 are 2000 year.
18 is also your matter? No, 18 is
No,
CBI.
CBI.
19 is yours?
Yes.
2000?
Yes. 19, 20 and 21 I am ready.
Okay.
And item 15. That matter.
50?
No, 15.
Yes.
Yes, that matter we seek some time for.
My lord, may kindly see how many adjournment it has suffered.
What is this matter?
That your lordship quashed a portion of that immoral.
Why you are seeking time?
No, my lord. In this case, another case which is my lordship has passed that order.
I know, understand it, but I can't keep on giving adjournment like this.
That case we want to file a petition. That's why I am sending the letter to what IS is not.
What letter? I gave opportunity. Otherwise, see, I have to. You will be in trouble. I gave opportunity Thursday, maximum Thursday. Otherwise, I will proceed with the matter. I can't see how many adjournment you have taken. 1, 2, 3, 4, 5, 6, 7 adjournments. There is a limit to that. Thursday. You do it or I will proceed with you.
Item 22, and that's the paper book.
First of all, when the matter was taken up, the State Council has no application of mine. They will not apprise the court. There is a judgment. And I passed some judgment, and thereafter you should have moved application.
In this case, that judgment will deal with that orders. But
when the subsequent judgment was passed, you should have pointed out this portion of the charges has to continue. Thursday.
Let's
make clear that no further adjournment at any cost will be granted. Do it or you don't do it. That's your problem.
I may pardon.
20th or 20th. 20th.
I beg pardon. Item 1, your lordship.
28. Next Thursday, Tuesday. Yes.
That's that item 22. Paper books are ready. If your lordship may directly register to serve a copy of the same to me. Item 22.
Paper book is ready there?
Yes, madam. In all 3 items.
Give it right now. Give it right.
So grateful.
22 paper books. Yes.
Item 1, my lord. Item 1.
Yes.
Item 1, my lord. Already filed everything.
Yes. Because the timeline, therefore I put it.
Oblige,
Yes.
Okay.
Judgment picture. Judgment picture. Okay.
Item 2 to 14 report.
Any report has come?
Item 2 to 14.
What about 2? Right. What about item 8? Is it against acquittal? Conviction. And report is no such person is in the name of Alok Biro. Kumar Bira.
It's convicted on section 20B. Yeah.
What is she report in item number 8? What is the report? Have you read it? Read the report. Appellant is Kumar Biro, and they are verifying about some Alok Biro. Just read it. There is no such person named Alok Biro. You imagine a name and start inquiring about him. Who is the appellant? Kumar Biro. You are searching Alok Biro. Right, circumstances. Alok Biro. It is ascertained that no such person in the name of Alok Biro, son of Ponchia Biro, in village so is residing. The report is saying that.
The surplus has given Kumar Biro. In number consequently, this is.
The report is saying otherwise. 10 is alive. Yes, 8, what do you want to say? Ready? Because he's not, they could not trace him. Do you have any idea?
I don't have idea. I have given also letter. Any reply.
They have no idea. No such person is residing.
Custody about more than 3 years.
More than 3 years custody.
Yes.
What is the offense?
20 BIHB about the NDPS Act. Conviction is about maximum punishment is 10 years. He has already undergone 3 years.
So show me period undergone.
Period is under the order dated 4/10/2027 to 2007.
No, from the record, just see when he was arrested and when he was.
That is mentioned in the order.
Let it come. You just find out the dates and all. Let me complete and I'll come there. Okay. It is in the report of you. Yes. No, yes. Report is your
Item 14 to item 14.
14 जो report আছে না সেটা করে দাও one more opportunity দেখি next Tuesday করে দাও ঠিক আছে yes
Item 16.
just find out the period undergone insofar as his case is concerned. Just find out from the record period undergone. He says that about 3.5 years he has undergone. He is not traceable. So in that case, I'll reduce the sentence and finish it up.
6 years.
6 year sentence. Item 8, na?
Yes.
Half of the sentence he has already undergone. Okay. Item 8 karo.
Fine of 10,000.
Now 6 years and pay fine of 20,000.
Kindly see order dated 4/10/7.
4/10
2007.
of this court.
Yes, madam. Passed in miscase number 6268 of 2007.
Yes. Mamatar submits that the
appellant
was arrested on censored and
21/7/2002.
using jail.
So
custody.
from the date of
Submits that
occurrence, he is in custody.
there is the discrepancy in regard to the weight of the article and also the article on
He is in custody. Released on bail by order. 4/10/2007.
Evidence affidavit is insufficient to convict potential. There is a evidence affidavit 3, 4, 5, and 7, and the period of custody or to the trial court means they can be dismissed. So from the date of conviction, the
From
date of conviction is
Conviction is not
date of conviction is
31st 10 2006.
31st 10
10 2006.
2006 conviction, and the bail granted on 10
4 10
Four-
2007.
10 2007
Seven.
bail by this court. This court. And during trial,
No, that is from the date of occurrence he is in custody. From the date of occurrence, he was in custody.
that is 21/7/2024.
Yes, ma'am.
21/7/2004. Taken to custody. So it's about 3 years, 2004. About 3 years, 3 months
Yes, ma'am.
custody. Yeah? 3 years, 3 months custody. How much is recovered? 5 kg.
No, ma'am. 11.
Huh?
11, excluding bag, but 10 kg. 5 kg from 2 bags. But as per the person who received reliable information, he has not cited as witness. Has not been examined. He is the ASI of the PS.
Hmm. Yes.
And so section 42(1) is not even complied, because though the reliable information was proved by the prosecution, but the person who entered the reliable information into secondary entry, he has not been cited as a witness.
Okay. Indicate. Yes.
42(1).
Yes.
Any such officer, being an officer in superior rank to the peon of Sipai or constable, to the Department of Excise Narcotic Control.
41-2. You're reading 41-2?
42, madam.
42 you're reading. Okay. Yes. Yes. Any officer? Yes.
Madam. Any officer, being an officer of superior rank, to a peon, Sipai or constable of the Department of Central Excise, Narcotic, Customs, Revenue, Intelligence, or any other department of central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order of central government, or any such officer, being an officer of superior rank to peon, Sipai or constable of the Revenue, Drugs Control, Excise, Police, or any other department of state government, as empowered in this behalf by general or special order of the state government, if he has reasons to believe from personal knowledge or information given by any person taken down in writing that any narcotic, drug, or psychotic substance conferred in respect of which an offense is punishable has been committed, any document or other article which may furnish evidence of commission of such offence or any illegal acquired property, or any document or other article which may furnish evidence holding illegal acquired property is liable for seizure or freezing or forfeiture of chapter 7 in enter into or any such building concerning so and so. So my if such officer has reasons to believe last provide my reading.
Which provides you?
See,
Last provided further.
second providing.
Hmm?
Provided further, if such officer has reasons to believe that such warrant or authorization cannot be obtained personally.
This is regarding search and seizure. Where does it say that he has to be examined?
Well, he has to be examined, but he has entered the information he reduced in the writing.
Maybe that is proved
But he has
otherwise.
to prove that document.
That he has, otherwise it is proved through the IO. It's not. Right.
That about my lord.
If you agree for undergone, I'll consider that. Period undergone, because he is not traceable. 3 years about with remission, it may be more than 4 years. 6 years sentence. You have already undergone substantive part of the sentence. So I'll reduce it to undergone period and finish it. That's better, isn't it? Okay, thank you. It will be. Yes.
Well, item 13. So I was the detail also submitted.
Next week.
First.
Yes.
Item 16.
Mr. Moody is waiting for which one? Mr. Moody is waiting for the CBI.
May I please your lordship?
Hmm.
On contract matter.
Item?
16.
Yes.
The order dated 7/11/2020.
Yes, compliance.
Last chance was given.
Last chance compliance.
Next.
Pension matter. Either you file the compliance affidavit today or otherwise the contemner will be present day after tomorrow. The engineer chief has to present physically here. Decide yourself. Because you have taken 3-4 times for compliance. I'll frame the contempt notice today and the engineer chief will appear day after tomorrow. Think over. Yes, next. It's a pension matter. He's suffering and the order is there. You are taking 3-4 adjournment for filing compliance affidavit. Let the chief engineer appear. Yes. Next.
Item 17.
Yes.
I am ready.
My lord, I am on behalf of Mr. Naik. Lord, he is on his legs, so I'm paying for 1 week time.
Hmm?
Mr. Naik is on his legs, my lord, so I'm paying that may be taken up on next week.
Legs for some time. Let him start arguing. You note it and he'll come and answer it. What do you say? Legs means he must be arguing in some other court. He will be available today or not?
Yes, ma'am.
Thursday you have another appeal.
Next week, my lord, and
No, Thursday because he is coming in any case for Thursday. One of your matter is
I am ready.
Thursday. Thursday. Let it remain. I will not touch it. Okay. Thursday. Okay. Because see, he is in any case he is going to answer in one of his matter partly argued, and this matter both the matter he will do so that he will be free. Okay.
yes, ma'am.
It is 99 matter. I will not adjourn. Yes. Thursday. Yes. This is PC Act.
Yes, ma'am.
Yes.
18.
Yes. 18.
18.
18. or-
CBI. 17, 18 CBI. 19 and 20.
What about 18?
17, 18, same, my lord.
Thursday.
Yes, ma'am.
All these
And
three
23
matters.
also, ma'am.
These are the 99 matter. I'm not going to hold it like this. Okay.
And 23, ma'am.
23 also. CBI.
Okay. 10. Let it remain in the list. Okay. Next. 20.
19.
19. Yes.
Item 19.
May it please. So matter relates to the trap case.
19.
19.
Ready? So let's start. Yes.
My lord, this is the trap case. The conviction is under section 13(1)(3), read with 13(2) and section 7 of the PC Act.
Yes.
The punishment is RI for 2 years on each count.
Yes.
Now the facts are the appellant is a senior clerk in the office, was a senior clerk in the office of DFO Bamra during the time. The complainant is a forest contractor. He used to visit the office of the DFO frequently. He had obtained a timber transit permit from DFO Bamra for transportation of 5 truckloads of timber.
Hmm.
One of the trucks broke down before the Bamra checkpost. And by the time the truck was repaired, the time limit on the TT permit had lapsed already. And he had to apply for a fresh TT permit. When he approached the DFO instructed him to produce the documents before the appellant, who was the lease clerk. And the appellant demanded rupees 2,000 as bribe. And after a discussion, rupees 1,000 was, it was agreed upon that rupees 1,000 he'll pay. Based on which, my lord, he complainant lodged an FIR and a trap was laid, and tainted money of rupees 1,000 was found on the person of the accused. My lord, total 5 witnesses have been examined from the prosecution side, my lord. PW1 is the junior clerk of the CTO office. PW2 is the sanctioning authority, the conservator of forest. My lord, PW3 is assistant engineer, and PW4 is the complainant himself, and PW5 is the investigating officer.
Yes.
And one DW1 has been also examined in favor of the defense, my lord.
What is your defense?
But the defense is, my lord, the defense is that the accused on previous date, my lord, he was previously acquainted with the complainant and he had advanced a loan. And that it was recovery of the loan itself. There is a promissory note to that effect, which was signed by one witness and the complainant as well as the appellant. And after keeping a Xerox copy, the promissory note was returned to him, which has been marked as Exhibit A in this case, ma'am.
Exhibit A, promissory note. Okay. Okay.
The original receipt was returned and he had retained a Xerox copy.
The Exhibit A has been brought on record through the DW.
Yes.
Defense evidence.
My lord, the defense plea has been taken. He has the appellant has taken this plea starting from his examination and section 313, my lord, and he has stuck to this. And it's also, my lord, the loan, the concept of this loan, that it has also been supported by PW 135 and DW 1. When
Your Lordship, may I kindly see the 313 statement that will clarify everything, Lordship. 313 statement, question number 19. If Your Lordship may kindly come to question number 19. What you have it, Madams?
There is a letter written.
That entire defense lies on that receipt, and that has never been exhibited.
Who are these people? When there is a letter written, very interesting letter.
Those are all after that and got of witnesses manufactured later on for defense purpose. So far, that Exhibit A is concerned, that happens to be the receipt. That is the crush of the matter. The entire defense revolves on that receipt. But, my lords, they have never exhibited that. If Your Lordship may kindly come to the question number 19 of the 313 statement for a moment. They are not able to establish their defense methods.
Let us see. 313, huh?
Yes, ma'am. It's question number 19.
1 minute. 313. We have 313 with us. Evidence required. $313.
The last question.
Last question, yes.
You have heard the entire
yes.
On record.
19, question
yes,
number 9.
Yes, ma'am. Have you got anything more to say regarding this case? Now, what is his answer? On 9/6/95, Friday, the complainant came to the office of DFO Burma. I borrowed rupees 1,000 from one, and she doesn't name that. On the same day at 10:30 p.m., I paid him a loan of rupees 1,000. My lord, he borrowed 1,000 from someone, and again he has given a loan of rupees 1,000. He had given one in writing to this effect.
He had given me
in writing to this effect. When Pratik Lakra was present there, he signed on the said paper. I also signed on it. On 27/95 at 12:40 p.m., complainant came to my office room, that is lease section. At that time, 3 to 4 persons, including one Pratik Lakra, were present there. The complainant paid me rupees 1,000 towards repayment of loan. Then I returned the original receipt, my lords.
And kept a Xerox copy.
Executed by him. I kept a Xerox copy of the said receipt with me. My lords, this is never exhibited. This Xerox copy of that receipt.
Yeah.
Prior to this, I had asked the complainant 2 to 3 times.
But she says Xerox copy is Exhibit A.
Just mention.
You see? Three times to pay the money, to which he was annoyed.
Yes.
He had.
And then there must that usual defense that is being taken.
But it has also been examined by the court and disbelieved in the.
Which is that exhibit, please?
Exhibit, can you say that?
Yes. What is that?
I documents are also not
My
complete.
lord, that has never been exhibited so far as my knowledge goes. My lords.
It is in the judgment,
That
and
is the crux of the matter, but that has never been exhibited.
not just that, the trial court has chosen to not believe it.
And my lords, if your lordship may kindly come to the witness of the decoy, that is PW4.
Letter country.
Yeah.
No, it is there. Just Xerox copy of the provisionary note dated 9/6/25. If you see the record, just see the record. After Exhibit 8, if you come down, in favor of Niranjan, errors also, only free. But in this, Niranjan Behra is not signed.
Yes.
Could be, my lord, because he had
He paid to
advanced the loan, and the signature of the other party was necessary. So it has not.
Okay. It's there in the down. Yes, see page 63. It is there. Page 63, Sri Murari Chanda Agarwal. So Adyo 9/6/1975 ଗୁରୁବାର ଦିନ ଶ୍ରୀ ନିରଞ୍ଜନ ବେହେରାଙ୍କ ଠାରୁ 1000 ଟଙ୍କା ମାତ୍ର ଧାର ସୂତ୍ରରେ ନେଉଅଛି। ରାୟପୁରରୁ ଆସି ଷ୍ଟେସନରେ ଓହ୍ଲେଇ ପଇସା ଦରକାର ପଡ଼ିବାରୁ 1 ମାସ କିମ୍ବା 2 ମାସ ଭିତରେ
DW1, 3, 5 and DW1 also have deposed that he asked for his money back, the loan amount back, and that is what he received.
Murari Chand Agarwal and P. Lakra. They have signed it.
So has mentioned that
You got it?
No, my lords.
Just see, after exhibit 8, if you go down, you get that. You get that. Exhibit 8. You go down, you will get it. List of documents, लिखा है list of documents produced by the defense, page 62 in the court of so and so, TR case so and so. Thereafter, Xerox copy of the promissory note, dated so and so, exhibited by Murari Chand, executed by Murari Chand Agarwal.
My lords are referring to Exhibit 8, my lords.
No, 8. You got 8?
Yes.
Go down. Go down. Then you see list of document, handwritten, list of document produced by defense. Go down little bit. It would be page 62. Go down. Xerox copy of a promissory note dated so and so. Prosecution. It was taken on record
it was taken.
with objection. If you see the format. Have you got it or not?
Yes.
Yes.
List of
Yes.
documents produced by the defense.
Yes.
62 page.
62 page. Above that, if you see
Yes.
two pages above that,
Yes.
you see the format.
Yes.
Format
List of exhibits.
special so and so. It is written. It is admitted objection
Yes.
in that format. Okay.
Yes.
Thereafter, you come down, you will get that letter. Get that promissory note.
It's above or below?
No, in ODI, down. Go down, then you get the promissory note itself.
Page 63, man.
Yes, 63. Sri Murari Chand Agarwal.
Yes.
This is the promissory note
Yes.
signed by Murari Chand Agarwal, P. Lakra.
Yes.
This is what is taken on record. This is the photocopy.
Yes.
And the defense is the original. Once the payment is made, original is taken and photocopy is retained.
Yes.
And this photocopy is taken on record with objection. This is what is the
Defense.
defense is.
Yes.
Now, let us
Kindly say how the trial court has dealt with this.
how the trial court is.
Yes.
Trial court was disbelieved it, saying that the handwriting
Page-
matched
Let us see.
any-
Let us see that.
Page 22, my lords, my kindly. Page 22 of the judgment.
Para.
My lords, it's, para 31. 21, my lords.
21. Yes.
Para 21.
Yes. It is the defense version.
Yes, it is the, I'm just placing it, my lords.
Yes.
It is the defense version, and it has been repeatedly argued by the learned defense counsel that the accused had put up a note recommending realization of penalty to the tune of rupees 9,600 from the complainant, and he was dealing with the lease section as senior clerk, which fact is undisputed, as DW1, the witness of the accused, has given clear corroboration to that effect. Admittedly, the complainant is a big forest contractor and belongs to Marwadi community. The accused is a clerk in that DFO's office, and from the evidence of the IO, who had also searched his official as well as residence in the native place, did not find much asset or ready cash, which suggests that he was not affluent to readily lend rupees 1,000, that to the complainant, who suddenly required rupees 1,000 on 9/6/95. It also does not appeal to the conscience in the circumstance of the case that the complainant would choose to come to the accused straight without going to any other person of his community at Bamra, if at all he felt any need of rupees 1,000 badly. His choosing the person who had officially put up a note to penalize him to expect loan from him also appears to be incredible, and no normal human being would run to a person who was not well disposed of to him for incurring loan. It is also not understood nor explained as to why a person of accused status would readily advance loan of rupees 1,000 on the asking for the complainant. If at all the complainant and the accused had intimacy, and no doubt they had prior acquaintance, the accused would insist upon execution of a document by the complainant for his advancing loan of rupees 1,000. If at all the complainant had incurred loan from the accused on execution of a document which was retained by the accused with him to be returned on payment of the loan, the complainant would not venture to take the assistance of the vigilance police to trap the accused paying the amount of rupees 1,000, which would subject him to criminal prosecution if the accused produced the receipt of the loan executed by the complainant. No normal person would take such a risk, and in the instant case, since there is nothing to show that the accused had then and there gave out that he had returned the receipt to the complainant which was in his possession, nor he produced the Xerox copy of the receipt which was in his own possession, as he has stated in his 313 CRPC examination, which is not a mere formality. The theory of advancement of loan and repayment of loan by the complainant appears to be highly improbable. The accused was being charged by the vigilance police of accepting bribe of rupees 1,000, and he had in his possession the Xerox copy of the original receipt, and he though advanced the theory of repayment of loan which he accepted from the complainant, his non-production of the Xerox copy of the loan receipt falsifies his plea of loan and receipt of the loan on repayment.
He introduced when the defense evidence 313 statement was recorded.
Yeah.
And the three reasoning is given. One is that he is a contractor, a contractor, affluent man. Why should he ask for money?
Yes.
And second is if the same clerk who is the accused,
why would he go to?
He has raised a bill.
Yes.
Illegal bill.
Yes.
And again, the complainant goes and asking money is very unnatural.
Yes.
Unnatural.
I mean,
and third thing is If the Xerox copy was there with him,
He has
when
not
was,
exhibited.
why has he not produced?
Yes, and
Yes.
so far detection report is concerned, this defense has been taken for the first time during trial. It is not taken during the detection of the trap. Whereas in your chief knows, my lords, in case of Tarsim Lal versus State of Haryana 1918 Supreme Court, the Honorable Apex Court has held that any plea taken thereafter will be considered as an afterthought just for the purpose of defense.
Okay. Yes, madam.
To that, I would answer that, my lord, if the depositions of almost all the prosecution witnesses
Let
are
us,
checked,
let us go to deposition.
Yes, ma'am.
almost everybody has deposed that he asked for the loan amount back and he took the money. And he, in his accused statement, also he has mentioned that. And the trial court, on merely on speculation, has said that because he is affluent, why would he ask? And also in the 313 statement, as sir pointed out, he took the borrowed the money and advanced it as loan. So doesn't make it improbable. Even if it does make it improbable, still it must be beyond reasonable doubt unless there is some presumption against the accused. My lord.
Yes, let us see the evidence.
My lord, come to the decoy statement. The complainant, my lords. The statement of the complainant.
PW1.
PW4, my lords.
4, okay. 4 first. Yes,
Yeah.
madam, read it. Let her read. 4.
The entire thing, my lord?
Read, huh? 4.
Read the entire thing, my lord?
Yes.
Huh?
Yes.
Yes.
In 1995, I was doing timber business. In the said year, I purchased 377 numbers of sal and non-sal trees from
Shamal Kishan and
Ramakishan and Khadu.
Khodwa Kishan.
who were the recorded tenants. The said trees were standing on the private land of Shama and Khedu. The said land comes
Bhojpur Forest.
Bhojpur.
under the jurisdiction of Laimura Forester. I cut the trees by engaging laborers in presence of DFO, ranger, and other forest staff. I got 4,500 cubic
foot.
feet of wood out of this said trees. In May 1995, I had applied for TT permit for transportation of the said logs. DFO Bamra issued TT permit. Lease section of DFO Bamra was dealing with issue of TT permit. During the relevant period, accused Niranjan Mehra was dealing with the issue of TT permit. I was issued with TT permit for transportation of 5 truckloads of logs and firewood. Out of 5 trucks, 4 trucks were loaded with logs and 1 was loaded with firewood. The trucks loaded with logs were to be sent to Jarikela, whereas the truck loaded with firewood was to be sent to Kuchinda. 1 truck loaded with firewood was unloaded at Kuchinda. On 28/6/95, the other 4 trucks were going towards Jarikela. 3 of them passed the Bamra forest check gate, whereas the 4th was detained near the check gate due to breakdown. In the meantime, the validity of the TT permits in respect of the truck which broke down became lapse. On 29/6/95, I went to the DFO Bamra along with the owner of the truck, Chintamani Mishra, who applied for issue of fresh permit. That day, DFO told me to meet the dealing clerk. The accused was the dealing clerk at that time. I approached him for the issue of TT permit. He told me to get in writing from the ranger and forester the fresh list and logs loaded in the set list of the logs loaded in the said truck. Accordingly, I submitted a list of logs with which the vehicle ORS 8621 was loaded. Thereafter, I went to the accused several times, but of no use. At last, he told me to pay 18,000 rupees at 4 rupees per cubic feet, out of which 8,000 he demanded rupees 10,000 for issue of the TT permit. I expressed my inability to pay rupees 10,000. My lord, this 10,000 has not been taken in the FIR, my lord, this amount.
Yes.
Later on, it comes to 2,000 and it was agreed 1,000 that is mentioned. I told him that I would pay the money only after lifting the logs lying in the truck near the check gate. The accused told me to pay him rupees 2,000 at least to get the TT permit in respect of the truck which broke down. I expressed my inability even to pay rupees 2,000 and agreed to pay him only rupees 1,000, which he agreed to accept. I unloaded the trucks near the check gate. On 19/7/95, the accused agreed to receive rupees 1,000 as stated above. I felt sorry and became annoyed of the behavior of the accused. I came to Jharsuguda Vigilance Office. From there, I came to SP's office, Sambalpur. I lodged a written report before the SP Vigilance Sambalpur. I wrote the report in Hindi. This is my report marked Exhibit 9. Exhibit 9/1 is my signature. On the same day, Inspector Vigilance told me to go to Jharsuguda Vigilance Office. I went there along with DSP Vigilance and other vigilance staff. We stayed there for the said night. On 27/95, I produced rupees 1,000 in the shape of 20 numbers of 50 rupees GC notes in the presence of vigilance staff, Gadnaik Babu, Malik Babu, and one Khan. From the vigilance staff, I came to know them. I narrated before them that the accused asked me to pay rupees 1,000. The notes were treated with the phenolphthalein powder. Garnaik Babu was asked to dip his fingers in the SC solution, but there was no change in its color.
Okay, these are preparation.
Yes.
Preparation.
Lordship, may
Then-
kindly come to para 6. That is relevant.
Yes.
Para 6.
2795 at about 10
My
a.m.
lords have it. Para 6.
Yes,
Sorry.
yes.
On
Right.
2795 at about 10 a.m. we proceeded to the spot. I and Khan were dropped near the spot, who were asked to go ahead. Others took their respective position near the spot. I and Khan went to DFO's office at Bamra. I entered the office of the accused Niranjan Meher. At that time, he was sitting on his seat and writing something. Khan was with me. When the accused saw me, he asked me whether I have brought the money, to which I replied in affirmative. He called him to the outside veranda. Khan followed us. On the veranda of the office, I paid the tainted money of rupees 1,000 to the accused. The accused accepted the money in his hand and kept it in his right side pant pocket. Then he came to his seat, and I also took my seat near him. Khan gave signal to the raiding party members. On receiving signal, the raiding party members came there. Vigilance sub-inspector challenged the accused to have received bribe money, to which he denied to have accepted any amount from me. The accused gave his version, stating that I had borrowed money from him. My lord, it has been taken right away, my lord.
The accused gave his version stating that
That I had borrowed money from him. My lord, this has been deposed to by almost all the prosecution witnesses. His hand wash was taken
this was his stand throughout. Yes.
from the very initiation.
Yes.
This hand wash was taken in SC solution. It turned pink. Accused gave his version as stated above after his hand wash was taken. Then Tripathi Babu asked the accused to bring out the money. The accused brought out the tainted money from his right side pant pocket. He asked me if I had borrowed any money from the accused, to which I replied in negative. Pocket wash of the accused was taken in a solution. It turned pink. It was bottled and sealed. The DS Vigilance compared the numbers of the GC notes with those notes noted down in the chit by him earlier, and the numbers tallied with each other. The IO seized the tainted money, chit of paper, and other incriminating materials under a seizure list. The IO prepared a detection report. I signed the said report. Exhibit 2/3 is my signature. Then it's cross-examination. It is a fact that on the allegation of cutting trees from reserve forest, which is within 20 chains of the recorded holdings of the tenant Khedu and his brother, a case was instituted against me, wide offense number 702 of 9394, becoming FIR number 46/1250 dated 10/10/93. My lord, the appellant had reported that the complainant had cut down some trees from the reserve forest, for which a hefty penalty was levied on him. There was some previous enmity, or at least there was some resentment on the part of the complainant.
Now you concentrate on one thing. If your defense version, why your defense version has to be accepted? If your defense version is accepted, see, insofar as the acceptance is concerned, demand is there, acceptance is there.
My lord,
Evidence to that effect is there. And now you have to discharge your honors.
Yes.
Why have you accepted it? That by way of that you have put forth your defense. If that defense version is to be accepted, then you are acquitted. If your defense version is not to be accepted, you are in. As simple as that.
my lord.
So now you concentrate on that part.
Also, section 20, the presumption part is also.
Presumption, rebuttable presumption,
Yes.
and is a reasonable defense.
Yes.
Reasonable defense, because there is a document. That is not oral defense.
Right.
There is a document, and the complainant, as you said, it is first time in 313 brought. That's not the case.
Yes.
This has been his stand
Yes.
throughout. Let us see who is the raiding officer, who is the
Yes.
who is this, and any suggestion put to him to this witness. Let us see. Yes, para 9. Just come to para 9. Suggestion was put. Whether I bought the amount and which I borrowed from him, and that I
Suggestion is there,
replied the hearing of the others that I thought the money which is borrowed from me. Okay. And it is not a fact that on 9/6/95 in presence of one clerk, P. Lakra, I have executed the document in
That's
writing
denied.
to the effect. So this is the defense.
Yes.
This is the
But
Lakra has been examined.
Lakra has perhaps not
No.
been examined, my lord.
Lakra has not been examined. Okay.
Other persons who were present in the office have not also been examined, only.
No, because the Lakra is a signatory to your promissory note.
Yes,
Lakra, have you examined Lakra?
No, he has not been examined.
from neither side, my lord. Not examined.
You examined whom?
We examined, my lord, one.
Who is that gentleman? Whom you where is the defense evidence? DW1 is. You have examined, madam, Lakra. Why are you saying no?
That,
DW1 is Lakra.
my lord, my documents are not complete. I'm working from a way.
So
Page 20.
you have examined.
Yes, DW1.
Yeah.
DW1.
Examine Lakra.
Yes.
So the Lakra has signed. In presence of Lakra, you have paid and you have examined Lakra. So therefore, your defense person has a this thing. It's not that you have taken the defense for the first time.
Yes. Consistent.
That's right. Consistent defense, and how it has to be treated, that has to be seen. Yes. Now come to the IO.
PW5. man.
PW5. Yes. Yes. Demand part is leaving. Demand is there.
Yes. Narrated the demand. The complainant narrated the demand of bribe by the accused for issuing TT permit. The third paragraph.
Para 4. Comes para 4. PW5. On the same day.
On
On
the
the
same.
same day at
At about
9 a.m., we proceeded to the spot in a jeep and reached there at about 12 noon. The complainant and accompanying witness were asked to go ahead to the office of the DFO, Bamra, where the accused was working. Rest of the members of the raiding party took our positions near the office. At 12:40 p.m., we received signal there. Then we rushed to the spot. We found accused sitting in his chair and the complainant standing near his table. I gave my identity to the accused and challenged him to have received bribe from the complainant. He became fumbled and remained mum. Thereafter, we took his hand wash in SC solution, which turned it. I preserved it in a separate clean glass bottle and marked it C for identification. The accused brought out the tainted money from his pant pocket. Shri Tapan Garnai compared the numbers of GC notes recovered from the possession of accused with those noted down in the chit, and the numbers tallied with each other. I also tallied the numbers of GC notes which I noted in the preparation report. MOs 1 to 20 are the said GC notes. I seized the said GC notes in the presence of witnesses. Pocket wash of the accused was also taken in SC solution, which turned pink, and the said solution was preserved in clean glass bottle, labeled and sealed and marked D for identification. I seized the paper chit from Sri Garnaik. I seized the lease case record file and one timber transit permit, book number 108 by 3205 from the office of the DFO Bamra.
para 7.
My lord?
Para 7.
7.
I have examined. Janab Pir Khan.
Janab Pir Khan. He has stated to me that as the accused saw the complainant, he asked him if he had brought the amount as asked by him. And he followed the complainant and the accused, and that in the corridor, the accused
Passing amount, thereafter they returned to the veranda and gave the signal to the raiding party.
Then when
Raiding party challenged.
the
I
accused
have examined
accepted
Tapan
the
Garnaik.
complaint, he became humbled and kept mum for some time. I have examined Tapan Garnaik. He has stated to me that the complainant narrated before us that accused was demanding a sum of rupees 1,000 for issuing TT permit. So saying he produced rupees 1,000 in the shape of 20, 50 rupees GC notes, and that the accused fumbled and remained mum and that the accused rest of it is not available, my lord. Cross-examination, I placed requisition in writing to the SP for supply of...
Para 10.
My lord, it is not a fact that the complainant did not narrate the fact of demand of bribe by the accused before us. It is not a fact that after the accused brought out the tainted money from his pant pocket, his hand wash was taken in sodium carbonate solution. It is not a fact that the accused did not fumble and keep mum, and that on being challenged, he gave his version that he did not demand and accepted the bribe from the complainant, and the complainant repaid his loan of rupees 1,000, which he had taken earlier, and he returned a document to the complainant executed by him towards the loan amount.
It was also suggested to. Yes.
He has returned at that time, my lord. At the time of detection, personal search of the complainant was not taken. It is not a fact that deliberately I did not take personal search of the complainant. The TT permit is to be issued by the DFO, but not by the dealing clerk. My lord, that is one of my defenses also. It is a fact that on 19/7 to 95, TT permit was issued in favor of the complainant and it was valid up to 27/95. My lord, the TT permit was already issued before this entire occurrence, before the
Yes.
the trap was laid,
Trap was laid.
the FIR was even registered, my lord. The TT permit in question was already issued. There was no
Issued
favor.
on
19/7/95, my lord.
That got lapsed. Thereafter, it has to be reissued.
no, it was reissued also.
Reissued
Yes.
also, my lord.
When the trap taken place, by that time it was already done.
Already done. And my lord, the DFO is
In
the
that case, section 7(1)(d) comes into play.
No, that's right. But if it is already done, you have to see the probability of the defense.
Yes, I agree.
Probability of defense.
Yes.
If it is already done, there is no occasion for him to go and pay. This is one way of looking at it. And secondly, there is an Xerox copy and consistent stand has been taken.
My lord, the
Standing.
lease clerk is not the competent authority to issue TT permit. The DFO is the competent authority to issue TT permit.
That's right. DFO said go and meet the clerk.
He just told that you give the you
And
produce
the clerk to move the file he had demanded.
Even
That's the case.
even if he is not competent, if he has no work to do also, my lord. Section 7(1)(d) of the PC Act comes into play, where it says even if a person gives an impression that he is in the capacity to do it, but it is not.
That's
his-
right. That's right.
My lord, here a false impression won't work because this person was acquainted with the DFO's office and he was working there. The contractor, as a contractor, he has been working for so many years, my lord. A false impression, misrepresentation won't work.
But
with
in
this
the raid
case,
also,
my lord.
no cash, no gold, no fixed deposit, nothing was found.
A whole entire raid was performed and nothing was found. Lord, demand should be for an illegal gratification of some kind, my lord. And there should be, my lord, some favor is involved and the person against whom the complaint is made must be in the position of granting that favor. Here it was not so.
Position, or he may not be having the position, but he can say that I'll get
Yes,
the
I'll
work
get it
done.
done.
Then also the
Get
seven
it
comes.
done, ma'am.
Sir, because this was not the first TT permit that he had applied for. He is a forest contractor since his entire career is of a forest contractor, the complainant, my lord. It is not so easy to misrepresent to him that the lease clerk will be
A
able to.
Marwadi involved in timber business
Yes, ma'am.
in Sambalpur, he is taking loan of 1,000 rupees
Yes.
from a clerk in DFO. You explain that.
My lord, the
You
appellant,
explain that, then you are out.
the appellant says that we were earlier acquainted with each
You
other.
know Marwadi is having timber business, what kind of money they have. Why should he go and ask to a clerk, give me 1,000 rupees?
My lord, on
That is the reasoning given by the trial court.
Right.
yes, my lord.
It is unbelievable story.
Yes, my lord. My lord, on that note, the initial demand was for 18,000 rupees and it came down to rupees 1,000 only because the complainant kept saying that I am not able to give you more than 1,000 rupees. So maybe he was not so affluent after all.
Yeah, logically, you maybe.
It is all of
Well,
a.
he was demanding, he said that I am not capable of paying 10,000 rupees.
Yes.
I can only pay 1,000.
can only-
Therefore, why should he pay illegal money?
At all, my lord.
That way you can think that he has a better bargaining power. Bargaining power. You are demanding 10, he could make you.
What actually happened is.
But when what circumstances the money was taken is more important. Somewhere I read
Yes.
that he was going to Raipur. In the bus stop, he need the money, therefore he asked.
Something
of that sort I read. Where is that? Where is that? Read it. It is not exactly the loan. He cut in a circumstances where he immediately needs some money. That's the reason the money was given. It was not exactly the loan in the
My lord. Loans.
general terms, Where is that part? Find out. Then that may be a possibility. In the bus stop, he might have seen.
And the statement also, he says that I immediately borrowed it from somebody and I advanced it as a loan.
So show me that part. Show me that part. Because trial court has not dealt with that part of it.
Trial court has, yes, not.
How many cases you have against you?
My lord, only
How many? Only one. Sure.
one appellant.
Because there is a letter written by many people against you. That's there in the record.
My documents are not complete.
To the
I have the paperwork, my lord. I'm working with these.
to this court. I'll show you. there is a letter.
But this appeal is this is one appeal, my lord, against one.
What about the antecedents, sir? Forest.
Antecedents, my lord, the IO has not verified any antecedents. in
That's
its
right, but
decision.
just I was just wondering, there is a letter. Where is that letter? Yes, this letter is written to then Chief Justice by 1, 2, 3, 4, 5, 6, 7, 8, 11, 12 people, saying that even after he is convicted and appeal is pending before the High Court, he is still indulging in all kind of.
It's not relevant, that is all I
No,
can
but relevant that I just wanted to know how many. If this is the character, then you might have created that paper.
Sorry.
That is the reason I'm asking. Anyway,
She says
That
could be,
should
ma'am.
neither is
take
not.
to account.
That's neither is not. Yes, let us see the defense evidence. EW1.
Ma'am.
What was the circumstances?
On hand.
1 minute. Let
Just a minute.
let me come, madam. EW1.
Pratik Lakra, DW1.
Not there. Pencil. Pencil go away. DW1, yes. Yes, let's see. Yes. I was junior class.
Both myself and accused Niranjan worked in the section of the DO's office. I know Murari Chand Agarwal complainant. They said Agarwal is a record holding contractor and he comes to our office regularly. On 9/6/95 by 11:30 a.m., Shri Agarwal came to our office and sat near Niranjan Mehra accused and asked Niranjan to lend him rupees 1,000. And as he was in urgent need of that amount, Niranjan agreed to pay rupees 1,000 on loan basis, and a document to that effect was reduced to writing. The document of loan was prepared by Niranjan Mehra in his
Own hand.
and Shri Agarwal signed on it. Niranjan paid the money, that is rupees 1,000 to Shri Agarwal. I also signed in the said document. On 27/95, I was there in the office of the DFO Bangla. On that day, by about 12:30 to 1 p.m., said Agarwal came to our office and told Niranjan that he had brought rupees 1,000, which he had taken on loan basis, and asked Niranjan to receive the same. He paid that rupees 1,000 to Niranjan Mehra. Niranjan Mehra returned the receipt to Agarwal, keeping the Xerox copy thereof. This is the said Xerox copy of the document which was kept with Niranjan Mehra, Exhibit A, after objection. And Exhibit A by 1 is the signature of Murari Chand Agarwal, and Exhibit A by 2 is the signature, and A by 3 is the signature of A by 2 is my signature, and A by 3 is the signature of Niranjan Mehra. After Murari Chand Agarwal returned money to Niranjan, after 3 to 4 minutes thereafter, 4 to 5 persons entered into the office and gave their identity as vigilance authority and charged accused Meher that he had received bribe of rupees 1,000 from Murari Chand Agarwal, and Shri Meher immediately replied that he had not received the bribe, rather he had received back the loan amount which Murari Chand had taken from him and returned him the document. In spite of that, the vigilance officers did not take any search of the person of Murari Chand Agarwal. The vigilance officials did not ask me anything to me, although I was present in the said office room. Cross-examination: Murari Chand Agarwal cannot read and write Odia. There is no endorsement in this document, Exhibit A, that it was read over and explained to said Agarwal. The witness qualified that it was read over and after its execution. There is no date put by anybody, including Muralichand, cited in the document. The accused Niranjan Meher is not a money lender. I do not know if he had earlier lent money to Shri Agarwal on any occasion. There are many big businessmen at Bangla and Marwari community to which Shri Agarwal belongs. Muralichand Agarwal himself is a big contractor. It is not the fact that my statement that around 9695 Muralichand Agarwal came to Niranjan Mehra and asked for a loan of ₹1,000 is totally false. It is not a fact that I am deposing falsehood regarding execution of the document Exhibit A. It is not a fact that the signature appearing in Exhibit A/1 is not the signature of Muralichand Agarwal. It is not a fact that I am speaking falsehood to the effect that original copy of Exhibit A was returned back to Muralichand Agarwal 2795. It is not a fact that I, in collaboration with accused Niranjan Meher, have manufactured this Exhibit A.
When the loan was given, that is on
9695 and the start was held on 2793. Around 1 month, 11 days.
20th July 2095 is the date when the raid taken place. At that point in time, the original was returned to. Yes, and further in collaboration with the accused, and I give it and I say the.
It was not produced before the vigilance officials when they came and challenged accused Meher about receipt of bribe from Shri Agarwal. It is not a fact that I am speaking falsehood regarding accused making statement that Muralichand had taken loan of ₹1,000 which he had just repaid and that the receipt executed by him was returned back to him. I cannot say when Xerox copy Exhibit A was made. After 2795, I am speaking of this fact for the first time in court today. It is not a fact that I am deposing falsehood to say that from the case of receipt of bribe of ₹1,000.
After receiving the amount,
Yes.
he returned the original.
My lord,
And Xerox copy retained.
prosecution witnesses one.
That has been disputed by the decoy in his statement in cross. I will take your lordship to that.
Yes,
deposition.
yes. Yes,
May I place it, my lords, that part?
let to complete.
That's PW4 para 9, your lordship, my candidate.
if you see the case diary, that on the date of reading at 5 p.m., the statement of the accused was also recorded. In the case diary, if you see. And in the examination of the witness, the accused, he has said that loan was taken by Murari Agrawal and he has returned.
The only person denied the loan is the complainant himself. All others have deposed
So
that.
far the deposition is concerned, my lord. In the cross-examination, he has refuted this.
With the mention, Agrawal present the complainant states that neither he had taken a loan nor been paying, but less but the loan after issue to yes. Yes.
Lordship, may kindly come to the deposition of the decoy, my lords, once again for a moment. In his cross-examination. Para 9.
Yes.
PW 4, para 9.
Para 9.
Yes.
Yes.
That is the cross-examination.
Yes.
My lords have it?
Yes.
By the time I approached the accused, 2 members of staff were in the room where the accused was sitting. Then he says, it is not a fact that as the accused saw me, he asked me to the hearing of other staff and Pir Khan as to whether I brought the amount which I borrowed from him, and that I replied to the hearing of others that I brought the money which I borrowed from him. This has been denied, my lords. He refuted.
Denied that I read it.
Yes, man. Then it is not a fact that on 9/6/95 in presence of one clerk, P. Lakra, I have executed a document in writing to the effect that I have borrowed rupees 1,000 from accused Meher, and that after payment of loan amount of rupees 1,000, he returned me the document executed by me, keeping with him a Xerox copy thereof. Now, this is important. The witness denies his signature on the Xerox copy shown to him during examination. The Xerox copy of the document is marked X for identification, marked with objection. It is not a fact that I have stated to the accused that when the accused was challenged to have accepted bribe, he gave his version saying that he received rupees 1,000 from me towards the loan which I had taken from him. That exhibit has been marked.
Xerox copy was confronted with him.
Yes, and he denies that.
Yes.
And it has been marked with objection. He denies his signature also.
And it is brought on record by defense.
Defense.
Yes.
Lord, the other persons who were available in the room were not examined. Except the complainant, everybody has deposed that he did ask that, did you bring my money? Did you bring the amount you had taken as loan? And to which he has given the money. Unless the accused knew by some divine intervention that a raid is going to be conducted, he would not have said that, have you brought my loan amount? My lord, the presumption under section 20 is not inviolable. It is not unrebuttable, my lord. Once it is rebutted by, and the onus of proof on me is preponderance of probabilities, my lord. Once I bring on some documentary evidence, my lord, then the burden of proof again shifts to the prosecution.
Again shifts.
Yes, my lord.
So, that document should have
Para 10 of the PW4 also read.
About the document, my lord.
Para 10 just read.
Yes.
Para 10.
Evidence.
My personal search, because the original was given to the PW4.
Yeah.
PW4.
Yes.
Whether the original was recovered or not.
No.
No, original was never recovered, my lord.
That was a personal search. Just see, para 10.
But my
My-
It reflects some light.
Malice, I'm just placing it. My personal search was not taken at the place of detection.
Yes.
It is not a fact that my personal search was taken deliberately.
My personal search, this is important. My personal search was not taken at the place of
Detection.
detection.
Yes.
There only the original was given.
Yes.
And it is not a fact that my personal search was taken deliberately as I was in position of
But thereafter, it was taken, my
was
lord.
not taken, in fact.
It
It's
is.
not
Yes,
fact
my
that I was taken deliberately in the personal original documents executed by me, taking the loan from the accused.
Yes.
It is not a fact that the accused demanded
From me, the loan amount, he has denied, my
the
lord.
clerk.
Throughout his consistency is there in
I felt
refuting it.
insulted that I posted this regime falsely. And it
He
is
has
not
totally
fact that
supported the
because
prosecution
the
story.
accused gave a note
Consistent story.
making me liable to pay penalty. I became aggrieved.
And that's
So
so
should the
factum of demand is concerned, my lord.
But the
that's-
personal search for the complainant, the Dokai customer, whatever,
Appellant, no,
has not been done
not
at
done.
this spot.
Not even of the appellant.
Personal search, if personal search would have been done, and there is a chance of recovery of the original which was returned, could be there. Why personal search is not done?
No, that's usually
If-
that's
No, not usually. If the stand is very clear,
yes.
if he takes a stand that the original was taken in money wise,
Detection, he doesn't say about this receipt factor, my lord. This is
Therefore-
of trial.
no. Therefore, read the case diary. At the spot, he says,
I haven't gone through.
see the case diary. Therefore, I saw the case diary. Case diary says, in the spot, he says that I have not taken money from him. It was the loan amount he has returned. If that is the case, and he says that the original Xerox copy I retained and original I gave, it was obligation on the part of the investigating agency to search the complainant.
During
Why search was not made?
that is
Otherwise, see, if search would have been done,
yes.
everything would have been unearthed there. The original could have been recovered. Since you have left unsearched, the original could not be, recovered. So he has a photocopy. What else?
On the other hand, he totally refutes this factum of receipt methods.
You
And
explain why have
he goes to the extent that he doesn't accept the
you have
signature.
to
even.
explain me
Yes.
in the face of the defense put forth by the accused. Was it necessary for you to have a search?
And it's usually in trap cases, your lordship knows, matter the complainant's personal search has not been done. Only the accused personal search has been taken.
Even the accused was not personally searched here.
No, it is not always, depending upon the type of defense it is taken.
And my lords, that loan was taken on 9/6/95. Date of trap is 27/95. My lords, would he be carrying the original receipt throughout, my lords?
Maybe, you see, these are
That is
the
quite
speculations.
improbable.
He may be keeping in the office. He might be keeping in the office because, see, the loan was taken from the office.
There's
The
a difference, my lords.
promissory note was executed in the office. Why should he carry it to the house? And the contrary, you search his house, you have not got anything.
No.
If it would have been there, it would have been recovered. So obviously it is there in the office, in the drawer. He paid the money. That can also be a situation.
Well, when the genesis of the receipt is being disputed by the decoy himself, he refutes the signature himself, my lords. So where does the document gets its sanctity and legal validity, my lords? This is my humble submission.
He says no problem. But an independent witness, who is also working as a clerk, he is not an outsider working. He says that in my presence it was given. I have signed here. Why should you discredit that witness?
Well,
Maybe because he is a defense witness.
No, my lords, because he is his colleague. This is my humble submission. He has come to his rescue, my lords.
But my lord, BW1.
At Lakra, he is also working in the same office, my lords.
Same office, but
Yeah, he's not
nobody
independent, my
will
lords. We cannot go to the extent
their
of
job
independence,
into
my lords.
risk, by defending a defending a
Birds of the same feather.
But my lord, PWs 1, 3 and 5 were not colleagues. They have also supported.
But they have supported the
In-
prosecution story
Yeah,
also.
okay. Yes, the entire story.
Yes, prosecution story they have supported, of course.
My lord, if your lordship will kindly glance at PW.
Because after a span of 2 months, my lord, carrying the same receipt throughout every day.
no, he will not carry it. Might have kept it.
That sounds a bit improbable, with due respect, my lord.
See, something could be interpreted
Malice.
or appreciation can be tilted in favor of the accused. It has to be
I understand.
given, not that.
My lord,
But he may be also aware of the fact that if he takes money without a receipt,
Hmm.
he will be shown to be a illegal gratification.
Maybe that is also one way of looking into it.
That is the thing.
One way of looking into it.
if your lordship will please come.
He knows these businessmen. They may that may be one way of looking at it. While interpreting it tilted in his favor, then that has to be.
Yes.
My lord, if your lordship will please.
File a written
come.
notice to me.
My lord.
Huh?
My lord, PW2, the sanctioning authority, my lord. I'll just read out, my lord, it's 2 pages.
Yes.
On 2/2/96.
What do you want to bring?
My lord, the sanction is not valid.
And section 19(3) is a state bar.
Well, this is those cases, my lord, where one person called Dhobel Behra, who was an officer, and that too here superannuated, my lord, basically it's like this. A IAS officer doesn't want to get examined in the witness box. So they must find a Pithu. And the Pithu is this gentleman, my lord, right through almost 10-15 years, he has stayed Dhobel Behra post-retirement also the sanctioning authority. One person. Ridiculous. Sir. Where is the application of mind of that man?
Stock witness kind of.
Absolutely. Sir. Well, after retirement, he continues. Because no one wants
And
to
see,
go to
the idea of sanction is really defeated.
completely destroyed.
Idea of
The
sanction.
President of India gives sanction when he writes that, and then he himself writes that.
That is the reason the honest officers are not willing to take decisions.
Exactly.
Because they take decision today. After the retirement, after 10 years or 15 years, they are summoned by CBI. You have taken some decision. So nobody is willing to take this.
Trust, my lord.
So therefore the idea of the sanction 197 or 19 for that matter
That is the salutary provision that has been made in the statute as a check.
to protect the honest working officer.
And if that is destroyed, my lord, nothing happens, my lord.
Yes, madam.
On 2/2/96, I was conservator of Forest Territorial, Sambalpur. For prosecution of accused Niranjan Meher, I received requisition from SP Vigilance, Sambalpur, Inspector Vigilance, produced before me all the relevant prosecution papers and the consolidated report of investigation. Lord, vague terms such as relevant prosecution papers and consolidated report of investigation are used. The draft charge sheet, the FIR and everything have not been produced before him. And the exculpatory material such as this note and the defense plea itself have not been produced before the sanctioning authority, my lord, which is necessary.
Yes.
I perused all those
Do you
papers.
have any judgment to show that the defense plea has to be placed before the sanctioning authority?
Yes, my lord, I'll if I am given 1 or 2 days, my lord, I'll just.
Because you have taken a defense
My lord,
right
not
from the
just-
inception.
Not just.
So whether a defense plea
Yes.
taken by a accused need to be placed before the sanctioning authority.
Yes, my lord. Including all exculpatory material that might exonerate him, that also must be placed. But it was also recently held. This honorable.
No, that's there. But
Yes.
there's a probable defense. Just examine this issue. A probable defense
Yeah.
of an accused need to be placed before a sanctioning authority, and sanctioning authority can go into it
Yes, I will.
to decline or accept it.
I will place some judgments, my lord, if I'm given a
This is
couple of.
basically an investigating authority. And
It's
therefore,
simpliciter says all available material has to be placed. But a probable defense.
Probable defense along with
supposing that
documentary.
material is there collected, madam,
Yes.
and is gone there, madam, he's supposed to be.
He's supposed to be.
They were not collected. Na?
Here.
Only it reflects in the case diary. No. Only the statement is reflected.
Yes.
But the document, the relevant document, the receipt, the photocopy of receipt is not, you have not produced photocopy of it.
Produce.
And the tactfully, the IO has not searched the complainant. He could have recovered the original,
Yes.
which you have given immediately. That is not recovered. So therefore, the sanctioning authority, what is the option for sanctioning authority? Your probable defense need to be examined or not?
I'll place some judgments that
You get
I'm given.
note it down and tell me.
Yes, my lord.
This is a legal issue.
This
This is a legal issue.
even this honorable court has held that
Mr. Rijvi, you also see
material
it.
must be
Yes,
placed before
I will
the
just place only one section, madam. Subject to your lordships. One section. Just
Yes.
place one section. 19(3)(a)
Oh, PCI.
PCI.
(19)(3)(a).
Yes, madam.
Yes. Yes.
My lords have it, madam.
Yes.
19(3)(a). No finding, sentence, or order passed by a special judge,
That's there.
That's
That's there.
there.
That is there.
even if there is any error, omission, or that is not fatal to the prosecution case. This is what I want to impress, madam. And this has been supported by Paul Verghese judgment versus State of Kerala in 2007, madam. 14 SCs.
A conviction cannot be upset on the basis of
Yeah.
that.
Error or
Because of
omission.
conviction. That is there.
Yes.
But this legal issue you to address. The legal issue.
the sanction was challenged from the very inception, and the deposition of PW2 I may be
Yes,
allowed
yes.
to. I received requisition from SP Vigilance Sambalpur. Inspector Vigilance produced before me all the relevant prosecution papers and the
Hmm.
on 2nd February 96, I was conservator of Forest Territorial Sambalpur. For prosecution of accused Niranjan Meher, I received requisition from SP Vigilance Sambalpur. Inspector Vigilance produced before me all the relevant prosecution papers and the consolidated report of investigation. I perused all those papers produced before me and discussed with the Inspector Vigilance on the matter. On being satisfied that there is a prima facie case against the accused under section 13(1).
It's all right. 13(1)(d) and 13(2).
13(2).
P-check and 7 P-check I accorded sanction.
I accorded.
Exhibit 3 is the sanction. Okay.
Yes, ma'am.
Next.
A file was being maintained in my office regarding sanction of prosecution of the accused person. The said file indicates the relevant papers dealt with therein and the date on which the Inspector Vigilance appeared before me for discussion regarding sanction of prosecution of accused. I did not peruse the TT permit book at the time of according necessary sanction. My lord, this was not even seized by the IO. The Xerox copy was seized or something, my lord. Why it was not produced? And how independent application of mind can be possible in its absence, it is
Yes.
difficult to comprehend, my lord.
Yes.
I inquired from the IO that the said TT permit book was seized by him during investigation of the case. Since I believed the consolidated report of the prosecution case submitted by the IO, I did not think it necessary to call for the said TT permit for my perusal, my lord.
Okay.
Question: you would not have accorded sanction for prosecution of the accused if you would have been appraised of the fact that the TT permit to lift timber in truck number OR08621 was issued by the DFO prior to the time. It has no link to this case because the accused was caught red-handed while accepting bribe and the TT permit was issued earlier or not is not to be verified at the time of sanctioning prosecution in this case.
Okay.
My lord, the DFO was this competent authority to grant the TT permit. The TT permit was granted before this entire raid, and the TT permit book was not produced before the sanctioning authority. There was a file being maintained. Even that was not produced. It has not come in evidence in the court also. And my lord, vague terms such as relevant prosecution papers and consolidated report of investigation are being used. It doesn't say that a draft charge sheet was submitted, the FIR was submitted. None of those things are mentioned even, my lord.
Yes.
I did not make any inquiry whether the plea taken by the accused was true or false.
In this regard, I want to know.
Yes.
Is it mandatory?
My lord, all material must be placed before the...
No, just we question para 4.
Yes.
I did not make an inquiry whether the plea taken by the accused was true or false. If a clear plea is taken
Yes,
by
my
an
lord.
accused,
Hmm.
which is reflecting in case diary itself,
My lord.
whether it is obligatory on the part of the sanctioning authority to examine it or not.
But I.
Because it's very tactfully you have asked this question, very specific question. And now you tell if in the absence of
The submission is that unless everything is put before the sanctioning authority, independent application of mind won't be possible. It will always, the opinion will always be tilted towards the prosecution. Unless the defense case is also, whatever has been, of course it is preliminary, but whatever is available must be brought before the.
that you are right, in general principle is that. But the question you have to search and tell me whether a probable defense put forth by an accused and which is reflecting in the case diary itself, whether the sanctioning authority need to apply his mind, whether the defense is plausible or defense is not plausible,
Yes.
and thereafter decide whether the sanction has to be granted or not.
My lord, on that point, my lord, I may be allowed a few days to.
Because he is not a post office. Anything you give and give the sanction.
Yes.
That's not the idea. Idea is you have to apply mind.
My lord, in this.
Apply mind to protect the officers who has worked in good faith.
Yes.
So if that is the case, the officer is cut red-handed.
Well.
He goes and says that see the money was paid because I had given him to on by way of loan. This is the receipt I have given him and he is paying back. So that is the acceptance is in good faith
Yes, my lord.
towards some other transaction. If that is the defense, is it not obligatory on the part of the sanctioning authority to look into it?
Yes,
And you have to simply say, okay, he can say that this it is not a possible defense.
Yes.
I don't agree. I proceed with the sanction. Where is the sanction? Simply you say that I peruse the record. I am satisfied that the case is made out and give the sanction.
Yes.
That's not the idea of sanction.
My lord, this honorable court, my lord.
And your question number, para number 4 to the sanctioning authority is very, very clear about.
I did not make any inquiry. Yes, my lord.
Very specific.
Yes, my lord. Lord, the documents itself, they were also not sufficient for the application of my.
This is again another issue. You
My
get
lord,
me.
my lord, recent case, my lord, this honorable court, my lord, Honorable Justice Panigrahi, my lord, in a CRLMC, he was pleased to quash the proceedings on the ground that exculpatory material must also be in favor of the accused, must be put before the sanctioning authority, otherwise sanction is.
19(3)(a) was brought to the notice of the court.
I'm not aware, my lord, I just.
That has to be seen. That is true.
Be withheld, especially it cannot be withheld when it is available. Deliberately, it cannot be withheld.
If it is withheld, if you can bring some evidence on record that a particular document or particular piece of relevant paper was withheld from the sanctioning authority,
Yes.
Then that's
then
a
in that
different
case, perhaps you have a case.
In this case,
And that has to be done at not after the conviction.
yes.
That has to be done at the threshold.
Beginning, my lord, it has been challenged, my lord. And my lord, in the judgment, not a single word called sanction has been used. Not that this person is the sanctioning authority, not that sanction is valid, nothing. The sanction, the entire word is not available.
It is not dealt with at all.
Not at all dealt with, my lord. Sanction has not been dealt with in the judgment itself, my lord. Everything is speculatory and I believe this, I don't believe this, it is the entire thing. My lord, the entire documents that the sanctioning authority has examined are relevant prosecution papers and consolidated report of investigation. Those are very nebulous
That
terms.
is a very wider term used.
Nebulous terms. What was there and whether it was enough. It has not been dealt with, not even at the judgment stage.
No, but this is a wider term.
Yes.
Prosecution paper means including everything.
Everything.
Should be, my
Case
lord.
diary and everything includes that.
Should be, my lord. But we don't know whether the FIR was there or not, the draft charge sheet was there or not.
How would you know? You have to put it. Have you put the question?
No suggestion, ma'am.
Then
It's not there, my lord.
how will you know?
Admittedly, it was not there.
Then unless you put specific question saying that see these are the paper not shown to you
Yes.
or these are the papers shown to you, something of that sort.
No suggestion on that.
That question is not there.
Further, my
That he has used a very vague
Yes.
term.
Prosecution paper.
All prosecution papers.
everything is included, something like that. And I don't know if a consolidated report of investigation is, my lord, if it is at all
Have you asked the question, what do you mean by consolidated
No,
report?
not available.
Have you asked what do
No
you mean by the
suggestions.
prosecution paper?
My lord, even then I will just submit, my lord, that even though the sanctioning authority himself was examined, nothing regarding sanction has been reflected in the
That's a
judgment.
different story. But you, since
And
you-
the TF
in the absence of your question
Yes.
to the sanctioning authority, what do you mean by the
Prosecution papers.
investigation report?
Okay.
What do you mean by the prosecution
Papers, yes.
paper? It has to be treated as if all the papers
Admitted.
were put before you.
My lord, the onus should lie on the prosecution to prove that we have given all the papers, not on me to challenge it. My lord.
Not necessary. If you don't question,
We have already said
use
that
a
we have
very
given
vague
all
term,
prosecution
saying that
papers.
everything was placed before me. You should have asked.
Yes.
Everything means what?
And my lord, no report was called for from the
The
DFO
entire
itself.
cross examination, only para 4 is only
Helpful.
will help you out.
Yes.
If at all you can find out some judgment.
My lord.
Okay. File a written note of submission.
My lord, judgment reserved, match.
Judgment.
Some days might.
You prepare a better the points which you have put forth
Yes, my lord.
one after another. You just
My lord.
put it and find the judgment and the proposition of law which I have asked you. And if you have any doubt, you can go to sir's place. He has heard everything. Then he can just very good. Yeah, you must go to sir's place and get some guidance.
Item 16.
I think you can just assist her in that point. That will be very helpful point. A probable defense need to be examined by the prosecution. I don't think there is any direct judgment on that.
I'll talk with the lawyer. I've got all the judgments and let me give it.
But there is no direct judgment as such. What I gathered, Mr. Rijvi can tell.
If he will come tomorrow this side, then we will ask him what all he has. Of his views.
Then the whole difficulty if the defense is not examined by the prosecution,
Well,
So,
then one application.
then complete non-application. And because
They just right.
because the presumption directly operates the moment you accept the money,
Absolutely.
and since it's rebuttable presumption, and the judgment says that if you take a defense at the trial stage, it will be not considered.
Yes.
And if you take the defense at for the
First
threshold, beginning only,
Yes.
the sanctioning authority has to apply mine.
Yes.
You can't have both.
You can't have. It's not possible. man.
Possible.
But
So
what
therefore,
it's all
this
mechanical, my lord. I have to see the all the sanctions, my lord. Very lackadaisical. Very
sanctions are
Always
very
like-
casually made. And he has hard time only reading that 19.1.
19.3.
You know what to do.
That reading, my lord, will not say that you can just ignore. If there is no material, my lord, the application of my 19 itself, my lord, is a valuable right like 197. How will it be taken away in a manner that the statute said, yes, but I concede, my lord, for the sake of argument. But the material has to be there. He has to apply his mind and give a foolproof order saying that I applied my mind, I am the authority.
And this is how I arrive at my conclusion and prima facie case is made.
Exactly, man.
And
Otherwise,
only
what
they
is
write, I peruse the document, I am satisfied that
that's not possible, man.
some reasoning,
Some
something.
reasoning. It may not, it's an administrative order.
Hmm.
Admittedly, my lord, a sanction is an administrative order. Even if administrative order, man, it has to speak for itself.
Yes.
I don't have to look somewhere else first. In fact, according to me, they cannot even support it with the document.
And everything is presumed. That's the whole
Absolutely.
difference.
That's the difficulty.
Can I just come within 5 minutes?
Yes.
In that content matter,
Huh.
they have given written letter of correspondence.
Huh?
Letter of correspondence, they have given that they have collecting the information about the different, he has worked more than 10 to 12 stations. Then say they want some time. I pray for some other day so that I have already talked.
See, 4 adjournments have.
That's that I am concerned with that. I have already intimated the views of the mind of the court. I pray for one.
But the fact remains that you have not complied.
No, no. Well, that's correct. What I have already intimated, I last opportunity, If not complied, lordship pass any order, we don't have.
I'll frame the notice. Let us frame the notice. If he complies, then I'll discharge the notice. I'll simply frame the notice today and place it for next week, because the contempt, we can't give the time like this.
That's your lordship means that.
The fact remains that it has not been complied.
Not complied with.
Delay, we don't know why the delay is. Maybe a genuine delay. But once somebody comes and complains and the court finds that compliance is not done, the first work is frame the notice. Notice has to be framed.
No.
If you comply, we will discharge the notice.
Yes.
If you don't comply, then second notice will be framed. Why you should not be penalized? Today, the first notice has to be framed.
Yes, madam. That. Because we have already.
Routine orders can't be passed like this. I have to frame the notice. I will frame the notice.
Yes, ma'am.
Frame the notice, and if you comply, the notice will be discharged. If you don't comply, then for penalty, another notice will be framed. As simple as that. Then I'll put it by framing notice. I'll put it for 7th. Sorry. 4th August. 4th August. I'll frame the notice today. Okay. This one, notice frame today. Yes.
Item 20.
He's waiting. Senior is waiting for which one?
Item 24.
Yes, 20.
Item 20.
Possible.
21.
Rashid, item 21, I pray for some time.
2000 April.
Thursday, I think.
Section
Let-
5, an old act of the Section 5 1D.
Okay. Undergone period.
That means that's
Find out undergone period. I can reduce. And employing that proviso.
proviso to Section 5.
Proviso,
Yes.
right.
That's the reason I pointed out that it's an old act.
Let's find out the period undergone. If you have undergone, then I can reduce, because in the old act there was a proviso
Yeah.
to Section 5. One of my judgment, I have said that
Abdul Hamid methods.
by giving reasons I can reduce the sentence.
Yes.
But in the new act, there is no scope.
There is no.
Minimum sentence is there.
Old act is there. Your lordships, Abdul Hamid judgment, your lordships.
Abdul Hamid's judgment, we can reduce it. Just find out, even one day also you have undergone, that's enough. I can reduce the sentence to already undergone. Okay, you find out and tell me. Thursday. Yes.
24.
Engage might not more than one occasion. Partner to my knowledge.
Yes.
And already
April.
I think my lords to first to do sanction order. It is exhibit 22.
Mr. Rijvi, you are appearing?
Mr. Das is appearing.
Mr. Das.
Is here.
Yes.
Well, this young man has just joined the bar and might not told you to be able to recognize it. Little effort.
Okay.
It was just some,
Great. Like father, like son.
Like son.
Yes.
Exhibit 22.
Exhibit 22. Yes. Yes. Exhibit 22.
Where are they?
Another exhibit 22. Exhibit 2. Is it DA case? Is it DA case? Huh? Disproportionate asset.
Yes,
Yes.
DA.
You highlight what are the points by the
Yeah.
time we take the document. What is your
Basically, my lord,
defense?
the sanctioning authority doesn't even say that I am the sanctioning authority. He says very interesting. I'll read that.
Yes.
Whereas it is alleged that the Sambalpur vigilance case number so and so, that Sri Srikant Mishra, OPS, Deputy Superintendent of Police, so and so place, was found to be in possession of assets disproportionate with known source of income during the check period 95 to 2006. Could not account for satisfactorily. During the investigation, it revealed that Sri Mishra, being a public servant, committed criminal misconduct in acquiring huge assets during the period 1/1/2095 to 2026, were found to be disproportionate. To his own servant. Whereas
What is the check period is? Check period is?
My lord?
Check period?
Check period, my lord, is 1/1/95 to 12/1/2006.
12?
12/1/2006, my lord.
Okay.
And whereas is so and so. Under and whereas the state government, after examining carefully facts and the SP's report and the above noted, my lord, state government, my lord.
1 minute. Exhibit 18. 1 minute. Exhibit I have to is there. Mm, 29%.
And whereas the state government, the state of Orissa, after carefully
Is a part of in the part of the paperwork.
yes.
Where is that page?
It is, I think, internal page, my lord. There is one document.
There are two volumes.
Yes, that one.
Volume 1 or
2, my lord.
volume 2, page?
Page 21, my lord.
21.
21?
No.
No, internal page 21. No, it's not paginated because that's from the document I have taken from the court.
Mm-hmm. Where is that? I got it, but it is not there in the paperwork. Anyway, where is that? Yes, read it. I got it.
Found it?
I got it.
Yes.
Our printout card. Printout. Yes. Yes, whereas it is alleged that
Yes.
also.
And whereas the state government, after careful consideration of the facts and SP's report and above noted matter, the relevant prosecution papers produced by the
FIR so and so.
building valuation, personal loans, statistics, per capita, so and so, and on proper application of mine, these two consider so and so has committed the offense, so and so. Now, therefore, the government of Orissa do hereby accord sanction and so and so, in position so and so, in offense punishable unto so and so, by order of the governor.
Okay.
And the sanctioning authority is signed. The sanctioning authority, my lord, how he is appointed, where he is appointed has not been elaborated anywhere. The sanctioning, my lord, has seen the previous orders, but all of them, ordinarily their own parent department has a sanctioning authority.
This officer, the officer on special duty,
yes,
has been examined.
Yes, madam.
Who is he? Let us see.
PW 15.
PW 15. Let us see PW 15.
Page 225.
225. Yes. Dhobei,
Dhobei Charan Sahu.
the one which you said.
All, I mean, all through, for years and generation, he has been there.
Yes, he has been-
For-
because
even,
he-
even after retirement. Even after retirement. One person could
Stock witness.
stop it.
Good sanctioning authority ଅଛି, science.
No, interesting thing is, my lord, kindly see.
Can you give me the in how many cases he has given sanctions? How many cases he has given sanctions?
Yes, probably I can. How many cases countless.
Let us understand
Yes, yes.
which figure, then I have to reflect in the judgment.
Yes.
If this is the application of mine, then the sanctioning provision has to be taken away from the statute book.
Off the record, my lords, in 32 cases where Vinod Kumar is the accused, Dhobei Sahu is this.
No, one accused
Why?
sanctioning officer I can understand, but not that in hundreds of cases one sanctioning authority and you have
He
posted
was
it,
given
then-
reappointment after retirement.
Then every government should have a sanctioning authority office,
Yes, yes.
post, sanction post,
And
cadre
he is
post.
That post.
You have create a cadre post,
Yes.
sanctioning
Now,
authority.
Interesting one, ex-cadre post now.
You
Because
create,
it's superannuated.
create a cadre post, sanctioning authority.
Sanction order is given by the government.
Where?
It is placed before the governor for approval. Only one person is to sign by the order of governor.
No.
Whether he has, see, somebody has to apply. See, what is the sanctioning authority? The authority who gives sanction. Governor doesn't do it.
It is-
Somebody has to apply mine.
Yes, it is.
Who has applied mine?
Specifically, it has been written in the sanction order that after careful.
Everyone.
The state government of Orissa, your lordship may kindly have a glance to sanction order itself, exhibit 22. The state government of Orissa, after carefully examining the facts, not special officer,
On behalf of Odisha, who has done it?
Who?
signing authority, he has been appointed by the government.
Where?
He has been appointed by
That's
the
the
government
question. That's the question.
to discharge the
Government of
duty.
Orissa has done it. Means some officer. Who is that officer?
He has been appointed
By who?
by the government.
Where? Where?
This officer who was signed.
It is not proved.
Is it a cadre post? Sanctioning officer?
No. When he was there, how could he be examined as an official witness?
No, that's,
How could he
you
be
may
charge seated as
you
a
may
witness?
be technically correct, but
No, charge seated witness.
propriety has to be seen.
No, what
Not that
authority?
one person is kept in the an office and he keep on signing all sanctioning.
My
What
lord,
is the application of
What
mine?
authority he had to go to the sanctioning authority and to discuss by placing all the materials? If he is not a government servant, your lordship may kindly have a glance to the evidence of PW
I'll hear
15.
you.
PW 15, your lordship may
I'll
kindly-
hear you. I'll hear you.
My lord, can you see which is the date when you
Let us understand.
Yes.
Let us understand. So this gentleman, what is his name?
Dhobei Behra, my lord.
PW
Dhobei Sahu, sorry, sir. Dhobei Sahu.
Dhobei Sahu.
And my lord, I will
PW 15.
15. My lord, I'll also indicate the date of the superannuation. What is the date of superannuation? Just tell. My lord, kindly see, let me read it. My lord, basically, my lord, 19 may, my lord, may be read, my lord. 19 says and sanctioning authority will be there, my lord, and he will accord sanction. Okay. That man is supposed to be applying his mind.
Yes.
Why not, I'll go to definition. On 5/4/2011, I was working as officer on
Which
special.
page you are reading?
Page 225, my lord.
225. 225. Yes. 225. Read it. Yes.
I was working as officer on special duty prior to this date. Vigilance or sanction against so and so on allegations of possession disproportion as asset between so and so. The proposal was proposed by the GA department and I held a pre-sanction discussion with the IO. Processed by the GA department. I dealt pre-sanction discussion with the IO, so and so, who appeared before me along with the documents in response to the notice issued against him. On perusal of the relevant documents produced before and after discussion with him, I am satisfied that there is a prima facie case against the suspected person, and after due application of mind, I prepared the detailed note and submitted it along with, very interesting, my lord, submitted it, the relevant material before the Honorable Chief Minister through Deputy Secretary and Chief Secretary.
The Honorable Chief Minister approved the sanction of prosecution. Thereafter, I signed it. So therefore, my lord, basically according to him, my lord, he's a post office. He admits himself.
It was placed before Chief Minister and the Chief Secretary. They
Yes.
have given it. Yes. The
And
procedure-
here, my lord, may kindly see in Exhibit 2, my lord, it becomes by order of the governor, this order. 22. Sanction your authority. My lord, may kindly see by order of the governor.
Where is it written? Go by the order of governor. Oh, by the order of governor. Yes.
By order of the governor.
Yes.
On the previous occasion, it was clarified before your lordship by referring to General Clauses Act, Section 3, subsection 6.
Well, I'll hear. Here.
State government. I have also filed my written note of submission. Your lordship will find this same.
I'll hear you.
I have mentioned everything else.
I'll hear you. Don't worry. Let him complete. Yes. Yes. Then your case is the officer who has given sanction has not applied his mind. It was placed before the Chief Minister and through the Deputy Secretary and the Chief Secretary. Chief Minister has applied the mind and gave the sanction.
And I have
This is what is reflecting from his evidence.
Evidence, my lord.
And from the exhibit itself, it appears that these papers were placed before the governor, and governor has applied mind. And reading up exhibit 22 and the evidence of PW 15, it is not clear whether who has applied mind, who has given the sanction.
Exactly.
This is what
That's a long and short.
This is what is the
Exactly.
case is. Yes.
And my lord, that is date of superannuation. I'll give those details, my lord. Date of superannuation. After that, he has been appointed again.
That is that will not entail you for acquittal.
Yes.
That may be an incidental thing, and corrective measure can be taken at that end.
That's all right. I'm not going in.
Yes.
The said sanction order is marked so and so, so and so. It's my signature, so and so, so and so, so and so. The notice issued by the IO to attend pre-examination is not available with me.
Yes.
Cross-examination. That's extremely important, my lord. The notice issued to the IO to attend the pre-sanction discussion is not available with me in the case record. That should be in the case record, my lord, basically, to know that I have called him. I do not remember the date on which the pre-sanction discussion was held.
Discussion with whom?
With the IO.
No, by whom? By
him.
But sanctioning has been given by either Chief Minister or Governor. So there is no discussion by
them. Discussion with him, with this gentleman.
He has no privy either to the Chief Minister or to the Governor.
No, my lord.
Even if he has discussed, he has to in turn go to the Chief Minister's office or Governor and discuss.
Yes. In event they are saying that. My lord.
But he doesn't say that.
He even doesn't say that.
He had discussed with IO, it's a different story.
Yes.
But it was communicated to the sanctioning authority, that is Chief Minister or Governor, whoever it is.
They don't even say who's the sanctioning authority, my lord. Interesting.
Yes. Therefore, according to you, there is no sanction in the eye of law. Yes. Now read to, come to 19.3. 19.3a.
You see it? Where?
PC8. Mr. Rijvi,
yes.
Do you have a copy? Please give. Here. Okay. 19.3.1.
Yes.
3A.
Yes. In fact, it's marked in my. Yes. No finding or sentence or an order passed by the special judge shall be reversed or altered by a court of appeal, confirming the revision or on the grounds of absence or any error or omission or irregularity.
Or any error or omission or irregularity.
Yes.
In this sanction required under
unless
the opinion of the court that failure of justice
has in fact
occasion there. This is the only rider.
Yes.
The rider is failure of justice has to be established.
Exactly, my lord.
Yes.
And that is what I am arguing. Only. Exclusively that. Stay though is not there, my lord. Basically, my lord, whether prejudice.
Failure of justice.
Failure of justice. Yeah. That's all. Then, my lord, I'll straight away go to the prosecution's evidence, my lord. PW 17, I think. My lord, I don't even want to bother, my lord, regarding the detailed note I have made. I'll give it to my lord. But I'm only cursorily putting to my lord, it's absolute travesty of justice of an officer who's a president award winner who doesn't pay income tax. The officer, the district judge writes that he's not paid income tax. My lord, I'm exempted from income tax because of my gallantry. And this is the way I'm treated, my lord. Few days before I was to retire, this is initiated, and I'm not made an SP, regular SP. I retired as SP in charge. My lord, I just want to take my lords to running page 102 in the cross-examination.
102?
Yes. That is, running page 266.
266.
PW 17, the IO.
Yes. Yes.
According to me, my lord, my submission is I do not need to go one step further qua any other evidence. This is enough for me, my lord, to get an acquittal.
Para 99?
Yes. 102, my lord.
Yes.
It is not a fact. I have not taken the sale consideration of the gold ornaments and so and so, so and so, so and so, and so. Then, my lord, thereafter, the last 4 lines, my lord. And next page, I'll read the entire thing, my lord.
You read that 102. You read 102.
Yes, 102 entirely, my lord. That I've already exhibit so and so. Permission was granted to purchase a second-hand car on so and so date, 70,000 rupees. It is not a fact that I have not taken 70,000 of the income of the accused. It's a fact the accused person earned 1,80,000 rupees from the sale of gold. It's a fact. On sale of gold ornaments further, I have submitted a report to the SP in so and so date regarding progress of investigation. Till that, my investigation revealed that during the check period of so and so, 61 lakhs, his expenditure was so and likely savings were so and so. On that day, the value of the checks, this so and so plus, thus the DA by then was 3,67,000, which is 5.47 of the income of the
10%. Less than 10%. Less than 10%.
Yes.
Yes.
And 6 months later, without any material. I would appreciate, my lord, he examined 3 other people, my lord, after that. Without any material. He writes to the IG. The same IO writes to the IG that, sir, it will not test of scrutiny, of judicial scrutiny to one surface. We should close the case. Subsequent thereafter, on 6/2/2009, no material added or subtracted, my lord. He makes a change of opinion. I submitted a further...
That has happened on 15/10/2008.
Yes, my lord.
15, I have noted here.
Yes.
15/10/2008, this report was submitted.
Yes.
Saying that the DA would be somewhere around 5.47.
Yes.
And thereafter on 6/2/2009.
Yes, my lord.
That is after about 3 months.
Yes.
4 months. What had happened? Yes.
I submitted a further report to SP Vigilance showing income of the accused in the check period of so and so at 51 lakhs and expenditure of so and so, likely savings on so and assets calculated so and so at 20 lakhs something, which is 38.7%.
Yes.
I rest my case here, man. Where is the additional material available to him? By the time he gave that report to the Inspector General.
He submitted a further report to us.
Yes, this further report, my lord, is no investigation. There is no investigation at all. Not a single additional evidence has come before him to say that it has increased. The same calculation he makes and makes it 51 lakhs. And then 20 lakhs this person has said.
It comes to 38.1.
Overnight.
Yes.
I cannot, my lord, another interesting point in the next para, I cannot say what items I included towards my assets in my revised calculation. It goes there also.
Yes.
How does this, my lord, make out at Section 3 of the Evidence Act a proof? I'm resting my case there, my lord. How can it become a proof, my lord?
Yes.
It's a disproportionate asset case, my lord. Other aspects, my lord, I'll go through in the earlier. I'm staying, my lord, whether I have to go one step beyond this, my lord. Same IO.
You answer me one thing.
Yes, my lord.
In a DA case,
My lord.
if the IO place the materials before the trial court,
Yes, my lord.
before the trial court with all calculation on, he apparently made a wrong calculation.
Yes.
Is it precluded?
Wrong calculation, arithmetic.
Complete wrong calculation. Suppose he says that disproportionate asset is about 200%.
Yes.
And files a charge sheet.
Yes.
Is it precluded?
He has to re-examine, my lord, under 173(8) and make a...
Now, what I am trying to ask you is whether the calculation made by an IO on the disproportionate asset has any relevancy?
Yes, it
because
does,
the trial court has to apply the mind.
No, don't know.
Whatever he says, maybe he says 3.4 or he may say whatever. What the trial court does, it is more important.
Yes, the trial court ignores this, my lord.
Let us see whether what is the analysis of the trial
court. No line of reasoning, my lord. I am only saying, my lord, in event the trial.
Your argument is
yes,
on 15/10/2008.
Yes.
He says that I have made the calculation. It is only 5.47% of the disproportionate. He says. Thereafter, he says on 6/2/2009, I submitted further report making it to 38.78. So therefore, disproportionate. This is what his report is.
Yes.
Even if this report is taken to be correct,
yes,
whether it is precluded, the trial court can't go into the asset calculation and arrive at a different figure?
Yes, I agree to that.
So how does it make difference whether what he says or not? Let us go to trial court record.
Yes, yes.
Let us go to trial court record and find out whether trial court has done it correctly or not.
Trial court, my lord.
In a disproportionate ratio, it is not a benefit of doubt.
No, my lord. I am only saying that it was incumbent on the trial court to look at this report and take into consideration this subsequent investigation and come to the conclusion that it is disproportionate. That's what I'm saying, man. I'm not going one.
You are right. There you are right.
Yes.
But according to me, in a DA case, these kind of contradiction in the evidence of IO is neither here nor there, because it's not a case you will be acquitted on the basis of benefit of doubt. You have to, it is a case of simple calculations.
Yes.
Let us see the calculation.
I agree. The calculation given by my lord, what he is accepting. He is accepting in toto the calculation made on 6/2/2009.
Then you have a case.
Yes.
Say that the trial court has not applied mind. He has simply gone by the calculation given by
that is all I'm saying.
Then you have a case. Let us see whether the trial is simply gone by the calculation given by the trial court. IO. Let us see that.
Adds it. Yes.
Let us see that. Let us come to the impute judgment.
Yes.
How he deals with the percentage.
I'll straight go to the findings.
Yes. What is the percentage trial court finds?
He says 40 something, little more than this.
Then he has applied mind.
No, 38%.
So whatever calculation the IO made is neither here nor there. Throw it in the dustbin. Let us see whether he has rightly calculated or not.
Yes.
If he is not rightly calculated, then you are out.
Yes. My lord,
Come to page 69.
I'll place that, my lord.
Yes. Come to page 69.
Yes. 15 onward begins, my lord.
Yes.
The total income from the net salary and
you are reading where? Page?
Page 14, my lord.
14 up for the the paper book you are reading?
Yes, paper.
Okay. Yes.
The total income from the net salary from other known sources of income for the charge period has been assessed by the IO at 51 lakhs, which is mentioned in the balance sheet described in final form. The defense has also calculated the income of the accused in a written argument and submitted the said income chart in the course of oral argument. The chart contains details of the income assessed separately by the prosecution and the defense are reflected herein.
Yes.
My lord, this net salary is 8.5850.
Yes.
That's the same in both places.
Yes.
GPF drawal is 3 lakhs. It's 3.75 as far as the defense is concerned.
This is defense. This is prosecution version, and this is defense version. Last one. Yes.
Bank loan is to 20.17, and it's the same there.
Yes.
Differential amount of salary.
First column, no problem. Second, third column, no problem.
No problem.
Okay. Fourth.
Differential amount of sale of old house in Chend. That is high.
4,917.
917, and it is 36 lakhs.
This is
36,000 on
use. This is use. Yes.
Amount received from LIC money back is 1,54,000,
This
and
is
it's
also
1,50,000
no problem.
both.
Yes.
Investment in bank, post office.
Interest on bank and
Yes.
post deposit. This is also no problem.
No problem.
Okay.
Third, my lord, vehicle availed from so and so, purchase of
This is also no problem.
tippers. No
This is also
problem.
no problem.
Here, my lord, the tippers are not, I mean, their loan give.
And the only you have to explain column 4.
Yes.
That is, it is 36.
Yes,
or
yes, yes. I'll
36.
I'll explain.
That's the only thing.
No, my lord, that vehicle loan availed, my lord, of 1,78,000 rupees of L&T Tippers Finance, it is not a loan given to him. It's a loan given to his son who had.
That is a secondary argument.
Yes.
We'll see the figure. Let us understand the figure.
Yes.
And this figure is also not doubted. Whether it will be calculated or not, that is a different. Factored into or not, that's a different story.
Yes.
But these figures are not disputed. Except the only one figure.
Yes.
That is 4.
Yes.
That is differential amount of the sale.
Yes.
Of gold and all.
Yes. Old house sale. Yes. Paragraph 11.
Yes.
Admittedly, the accused person had purchased the Chend house and sold the same to one Sandeep Kumar Patnaik, PW7, for 1,50,000 in the month of July 2002 by a registered sale deed. According to the accused, it was purchased at 1.3.7 so and so, and therefore he earned a profit of 36,000 so and so by selling it to PW 7. As per allegation of prosecution, the house was purchased from the Raulkela Development Authority, and he had paid some installments before the check period, tuning to so and so. And during the check period, he has made a payment of 1,13,000, which comes to 1.45. Paragraph 45 of his deposition has admitted that he has paid 1,45,000 for purchase of the Chend house by paying installments. And further, he stated that 1,31,000 so and so was paid
and
by
it means
check period.
We'll go into the reasoning. Come to page 69.
59.
69. Paper. Now read it from the top.
Yes.
The accused has not in between fourth line.
69, my lord.
69. The table.
The accused has not produced any document to prove 1,13,000 from his salary during his check period.
Yes.
This is a
in view of the above discussion, the facts and law, we calculated the total income of the accused during the check period, and the detailed incomes are described. This is the income.
Yes.
The trial court calculates.
Yes.
Let us see which are the things you don't want to discard.
Yes.
First of all, net salary, it will remain. You can't do away with it. This remains. Okay. Next, GPF part final withdrawal of so and so for the construction of the house, Raulkela.
Yes, ma'am.
GPF you have withdrawn, that you can't say no.
No, madam.
That's okay.
That's no problem.
Which are the disputed figures? Let us see. Understand.
Yes. One disputed figure is this one.
Insofar as the disputed figures are concerned, what is the reasoning given? We will see.
Yes.
The reasoning is correct, then it's all right.
Yes.
Otherwise, no.
Yes.
Write down. Sorry. Bank loan.
Yes.
You have taken bank loan?
Yes.
Bank loan? No dispute?
Yes. And that is that he has calculated as my income.
We'll see that.
Yes.
Reasoning.
These are the things that happen.
And then bank loan you want to go into,
Yes.
Okay. Differential amount on the sale of the old house is this. Differential amount.
Yes.
Vehicle loan, these are the income. Vehicle loan is taken as an income.
Yes.
Okay.
So he makes it
refund received on the money so and so is income. interest on bank deposit is income. So, yes.
My lord, this
Which amount?
yes, at
loan?
1.9, this is what I have made, this is what is stated to be my net receipt from my sale of my property, my lord. Admittedly, it's 31 lakhs, 31,000 something. And it is made, I don't know how he can make it that after 5 years I sell the property and it only becomes, it rises only by 491.
What document you have produced that you have sold it?
Sale deed, everything, every
Sale deed
detail,
is there.
yes.
Sale deed is there.
Yes, yes.
Okay.
Sale deed has been produced.
Let us see next page.
Yes.
Expenditure.
Expenditure, my lord. Expenditure as per prosecution check is 6 lakhs 55. Ours is 2 lakh 14. Educational expenses is 4 lakh something. It is a little less, that doesn't really matter. Telephone bills is 1 lakh 68,000. Ours is 1 lakh 2,000, so on. So for the entire check period, maintenance of vehicles is the same. Dog, my lord. Maintenance of dog is calculated. I had a what they call a dash hound. They calculated on the basis of a dog which is what's that called? Doberman Pinscher, who was dead long back. And they say that this is the amount of money I've expended on my dog's expenditure.
What is that?
Yes.
Dog's expenditure?
70.
Okay. Yes.
Then medical expenses other than amount claimed under reimbursement, nil. Nothing I have claimed more than that. Then this margin money, my lord, 1 lakh, has gone for my son's income.
Margin.
Son has given my son is an assessee for over 2 years, my lord, return filed, and son has given the money.
Yes.
Margin money, not from my account.
Yes.
Insurance premiums is the same, my lord. Stamp duty and registration charges is 45,000 something. This is 34 something. Not very much. Locker rent is the same, my lord. This again, road tax and registration fee for vehicles.
But the margin money which you have, you say that is paid by your son.
Yes.
That is not included. That is not included.
That has been included, my lord. 1,001.
In the column it is written not.
1 lakh. 1 lakh is included.
The column, last column.
No, that is my expenditure of defense. Defense says I have not incurred that money.
Okay, defense. If you are defense, okay.
I have not expended. Then, my lord, road tax and registration, that is all on those vehicles, my lord.
Yes.
Of the trucks, my lord, L&T has given a loan to my son, not to me.
Yes.
And he's servicing the debt, not me.
Road tax. Miscellaneous expense.
Then repayment, my lord, is same, my lord. Variable, non-verifiable expenditure, my lord, 39,000 rupees is not computed by us. Obviously, there is no variable, non-variable. Cash paid to so and so, my lord. TK Mishra and others, my lord.
2,50,000.
Yes. Nothing has been paid. There's a loan taken, hand loan taken, nothing paid, paid later. Relation.
Yes.
Paid later. And my lord, income, loan, admittedly loan taken. Loan taken by me.
Okay.
And I didn't return it. I returned it some at the date of before superannuation, some after. And income tax return has shown all that.
Yes.
The total income, my lord, is 22 lakhs and then 12 lakhs.
That's the prosecution case.
Yes.
23 lakhs,
Yes.
15,000 shown.
Yes.
Your case is 12 lakhs shown.
Yes.
Yes.
My lord, may kindly read. The item 1 under which head expenditure is alleged by the prosecution, per capita expenditure, living expenditure, and so on, so, clothing, footwear, during the check period is 6,55,000. my lord, one is talking about those years. And I have a income from my son also. And I'm always in government quarters. Item 15 relates to non-variable expenses of 39,900.
Yes. You just tell me the calculation, that's all.
Yes.
We'll see. Calculation part we'll see. Which item is to be discounted.
Yes, this amount, my lord,
Yes.
it cannot be that I have spent 6,55,000 rupees that item.
Therefore, what exercise has to be done is,
Yes.
as against each item which has
We have
been
given-
taken by the trial court, against each item you have to tell what is your
Yes.
against each item.
Yes, yes. We have a
Insofar as,
calculation already.
insofar as income is concerned, whatever incomes are there, see, net salary income you can't dispute.
I'm
There is
not disputing. In fact, they have not even taken that. Some of them, they have not even taken that. If my lord
whatever,
calculates.
see, for example, the GPF. GPF is a recorded thing, you can't dispute.
No. How can I, my lord?
So which are, see, for example, vehicle loan is also not disputed because you have taken the loan. That is taken into the income.
No, vehicle loan income, my lord, that vehicle loan is shown, my lord. They say 1 lakh I have paid, the margin money. It's not paid from my account, my lord.
So in that regard only, you whatever you want to say, tell me.
Yes, yes.
So column by column by, otherwise there is no end. You have to, this is basically a calculation.
Yes, yes.
You tell me the calculation.
Yes.
Which head, what should
All
be
right,
the value?
All right. We have given a calculation below. I'll just prepare a calculation. give it
You
to
just give a comparison, then
Yes.
we'll see
Yes.
whether it comes to 40 or it is actually 5.37 or it is, thereafter you will get the benefit of that evidence.
Yes.
Whether whether the trial court has independently applied the mind or trial court is swayed away by the calculation given by the
In fact, he has not only accepted that, he has accepted something more than what the prosecution has.
Then if the trial court has not relied upon what is the IOS say, why should we get into what the IOS say?
but-
Just forget it.
I have explained every detail, my lord. How can they add, my lord, how can they add money which is paid by me? Even 1% of it being taken out, my lord, doesn't make out the case.
So you focus on a particular figure.
Yes.
Which should be, in fact, should be taken out from the record.
Yes.
So it can't be factored into.
Yes.
If that amount goes, it will straight away reduce down from 40%
Hand loan,
to.
my lord, has been added as my income. My hand loan. What do I do, my lord?
No, for that, what is the evidence you have brought?
Yes, evidence has been over a period of time in the next subsequent years, I've paid back. Something has been paid then also.
What is the evidence to that effect?
Yes, yes.
As against that hand loan,
And some of them have been paid even after the check period.
those evidence has to be
Yes,
seen.
yes.
Evidence has to be seen.
All
You
right.
will prepare and give.
Yes, we have got it in my lord. I'll give it right away.
Then we'll continue or Thursday?
Whichever day.
Thursday is better in continuity.
Yes. Because one of them goes away, my lord, I'm not there.
You focus on that figure. Which figure, the biggest figure you want to take it out from the record.
Yes.
You figure on that, it satisfy me, I'll take it out. Then the amount, the percentage reduces down.
Yes.
Instead of going here and there.
Yes, yes.
Let us concentrate there.
Yes, we will
Which is the biggest figure according to you?
Yes.
Should not have been taken into consideration.
Absolutely.
That figure you concentrate there.
Yes.
Satisfy me on the basis of evidence.
Yes.
If it is to be taken out, it will be taken out. If it is taken out, completely reduced down, the
All right.
percentage will reduce down.
All right.
You have to bring it to below 10, that's all.
All right. All right.
And the argument of sanction and all, it's a very good argument, but in a DA case, how will you get over the 3(2)(a) unless you show from the evidence that it is really prejudice to you.
Yes, yes. Well, we have shown that also, madam. We exhibited that, madam.
The prejudice means had this calculation would have been placed before the sanctioning authority,
This
he might not have given the sanction.
I am only saying one thing further, my lord. Where is the material before the honorable judge, my lord, when they accept that they had said 5.47 and a new figure is made? Where is his calculation that 4.7 is wrong? Where is that calculation, my lord?
I will accept that argument,
My lord,
if you can show from the judgment
my lord.
that the trial court has not independently applied his mind. He has only gone by the calculation given by the IO.
I am only saying, my lord, it is incumbent on the judge to look at when this is brought in the cross-examination, my lord. This material has to be looked at by the judge. If the judge ignores it also, that is enough for me, my lord, to get a benefit. Because of the fact, my lord, they should have, the honorable judge should have seen that what is the figure on 4 months before and what is the figure on that date. I am stating that much, my lord, that if those figures have to be, my lord, both of them have to be dealt with once it's at coming cross-examination. The court is not debarred from asking them to show that report.
No, what I am hypothetically asking you a question is,
My lord.
in the first report on 15th of October 2008, if the IO has given a calculation saying that it is only 5.47%, it is completely a wrong calculation, suppose. Is it binding on the trial court? Trial court has independently assessed and thereafter found that it is 40%.
Well, who gives the material, my lord, to the trial court?
Which material is foreign to the...
That is what I am saying. Well, which of the two material are conclusive?
So that is what you have to show me.
Yes, well, I am stating...
Whether the trial court has considered some material which was not before him.
I am saying that this material of that 5.47, my lord, when it came in cross-examination, it was incumbent on him to call for that calculation. That is not called. That is
incumbent upon the trial court.
Trial court. Because he should have told when this cross-examination...
Then if the trial court has to call for the calculation from the IO, then trial court need not do anything. You give your calculation.
No,
I believe him. I don't believe.
Calculation comes from us, my lord.
No, trial court is in a DA case. Trial court has to independently assess.
Yes, but that
if an independent assessment is to be done by a trial court,
my lord, what is saying?
How does it make difference whether the IO has said what?
No. If the IO has said one thing in one place and another thing another, my lord, and if he is accepting the second one and add second one, my lord, it was incumbent for him to see a prejudice is caused to me for the reason that there was a calculation earlier where the prosecution didn't bring it to the fold of their charge sheet which was filed. If they had indicated this, my lord.
Suppose imagine a situation,
my lord,
an IO calculates collect all the papers and without making a calculation, simply he says that he has a disproportionate asset.
My lord.
Simply he says, he makes no calculation and files the charge sheet.
My lord.
What will happen?
According to me, my lord, without any...
The charge sheet is bad.
Yes. If there is no calculation of charge sheet,
no, he might have calculated himself. According to him, he simply place all the documents saying that as per the calculation made by me, he will write down in the bottom of the charge sheet, as per the calculation done by me, the disproportionate asset is beyond 100%. He writes it and files it without giving a calculation at all. How will
the court...
Whether that charge sheet is bad in law?
Bound to me, my lord, because of there is no material, my lord.
No, materials are there. All materials he will place, but no calculation.
Calculation, my lord, is the substratum of the case of the prosecution of DA case.
No. He might have calculated, but he will not form part of it.
So obviously,
calculation sheet will not give. All the documents he will collect and place it as a charge sheet. Simply writing in the, I have calculated myself, and the disproportionate is beyond 100% or 40%, whatever. He gives it. Whether that charge sheet is bad in law.
All right. I'll address that on that.
If that charge sheet is not bad in law, yes, whatever calculation is make is inconsequential because the trial court is independently assessing.
Independent.
That is what is the law on that?
No, I am not saying something is wrong, my lord. I am saying that when a charge sheet is filed, that is the starting point of prosecution, whether it's a disproportionate asset case or a case under section, it's a criminal case, my lord.
Yes.
The criminal case has to be proved by the prosecution, not by me, my lord. Clearly. I don't have to prove anything. Beyond reasonable doubt, they have to prove. when they have to prove, my lord, the onus is on them. It's not the onus on the court to prove. The onus has to be discharged by them. Whether it's
So
disproportionate.
you indirectly you are saying that unless a calculation is given by the IO, how will I discharge my?
Exactly. How will you know?
He has to give a calculation and justify it. Then only I can defend it. That's what you are.
I'll complicate it that way, my lord. And apart from that, my lord,
You're right. That's we are just.
No, my lord, debating a matter. It's very nice. It's
With
good.
great
No, my lord, I am saying one thing.
Then what I just wonder, I'm just wondering. If the IO collect all the documents, he doesn't make a calculation. He makes a calculation in
Income
his
tax
house.
department can assess
And
it.
simply write that this is what is according to me.
My lord,
What will happen to that?
Nothing can be done, my lord, because the prosecution, the initiation of the proceeding under the PC Act clearly is a penal provision. And
It's like a supplying ground of arrest kind of situation.
that's
You
right.
you need to know how he has calculated so that you can defend yourself.
To set the criminal law.
That's the idea.
Yes.
That's the idea.
Set the criminal law into motion, there must be material available to him to come to the irresistible conclusion beyond reasonable doubt.
Then you show me if any judgment is there.
Yes.
It is obligatory on the part of the
Prosecution prove its own.
No. Investigating officer who filed the charge sheet to give a calculation.
Yes. All right.
I was given the prosecution. If the he is not the
ex officio bad.
He is
then
not the
what will
IO.
happen?
He is not the IO filed charge sheet. The IO has filed the charge
No,
sheet.
we are examining something else, Mr. Das.
Yes,
Try to
that is
understand.
there.
If a calculation is inevitable in a charge sheet, if the calculation is ex officio wrong, then what will be the consequence?
PW
Can you throw this calculation?
PW 17 is the
dustbin
part
and
IO.
proceed?
PW 16 is the IO filed charge sheet. Your lordship will be satisfied if your lordship peruses only 2 pages.
No. What he says, try to appreciate.
Detail given.
No. What he says is on 15/10/2008, the same IO gives a calculation saying that the disproportionate asset is 5.47%. And subsequently, after 2-3 months, he gives another calculation on the basis of same set of paper. The disproportionate is 38% so and so. On that basis, charge sheet is proceeded.
No.
1 minute. Charge sheet is proceeded.
Charge sheet
That's
is
what
not
he is showing from the evidence.
Charge sheet is not filed on that score. Charge sheet has been filed by PW 16 after receiving the case diary from PW 17. So your lordship,
That is another.
that is not a calculation. That is only internal communication between the part IO and the superintendent of police. That is not the charge sheet. The charge sheet which has been filed against that charge has been framed. Your lordship may kindly have a glance to page 232. 232, only 232. Your lordship will be satisfied. Your lordship will be satisfied if your lordship peruses page 232.
I'm sure you will make me satisfied, but let us understand his point.
The IO
He is raising a legal issue that has to be answered.
The IO is PW 16 who has filed the charge sheet. He has given the details and it has been vividly described the income, expenditure and etc. And he has calculated the DA at 21 lakhs, 3,016.
What is the percentage according to him?
38%.
38.
37.13. The IO is PW 16. The charge has been framed according to the IO. That amount, the portion which was shown by my respected senior was an internal communication between the SP and the part IO. Investigation was completed thereon.
Charge sheet
During that time, charge sheet has been filed subsequently by another IO.
Okay.
So charge has been framed as per the charge sheet, my lord.
Okay. We'll see. Look into that which item has to be.
Yes, apart from that, my lord, he also frontally answered this. My lord, may kindly see.
And in so far as the sanction part is concerned, we'll put it rest. We will not go into sanction part right now.
All right.
You have to show me otherwise that you are prejudiced. That last part.
Yes.
19(3)(a).
Yes,
Last part you are prejudice.
Yes.
So therefore, it has to be reversed.
yes.
That you have to show.
I also
Prejudice in the
expect,
sense the other item.
Error includes competency of the authority to grant sanction. It is
That's
there.
there. That's there.
So
No,
I have written
last he's emphasizing on last
prejudice,
last expression.
failure of justice.
Failure of justice.
Failure of justice. No, the expression is not failure of justice exactly. Expression used here is
A failure of justice has in fact been occasioned thereby.
yes, failure of justice has in fact an occasion there.
The competency, it has been explained. In the explanation, it is there.
So therefore, I am saying 19 will create problem for him.
So it is there in the General Pradesh Act. I have mentioned in my written note of argument. Who is government?
19 is very clear. Why should
19 is clear. 360 is clear. Who is state government? Who is governor?
No, I need not go into it.
Yes, sir.
I need not go into it. Because 19 is very clear. Yes.
So may I pray, my lord, in the cause list,
Item 7, it is
Waiting.
7 11 plus 2.
we are in confusion, my lord. My name may kindly be reflected in place of Srimanta Das. I have filed appearance memo, but we are in confusion.
48, which is
Sanjay Kumar Das, Standing Counsel Vigilance.
appealing for the vigilance that his name is not reflecting the cause.
Fix a date, time for me, but I will give you that.
Yes.
Fix a date and time.
Yeah.
Thursday.
Thursday.
Thursday is fine.
Thursday.
Thursday is fine.
2 o'clock. You come 2
Yes,
o'clock.
we need to.
Yes. 2 o'clock. We'll continue. Okay. Thank you.
Item 9.
93 you mentioned in the morning. There is no one for the state. They are scared of you, it seems. Yeah.
Well, actually, I'm not on item 27. It's a very old case.
Yes.
26. And my lords, neighbors fight amongst the neighbors. My friend was appointed as advocate because the informant's advocate has also disappeared. So, my lords, he had gone to the, she had come to the mango orchard of the.
You were appearing earlier.
Yes, fellas, like before, for the accused, no, for the applicant.
Okay.
Respondent.
For complainant.
No, he was the accused. He was convicted in the trial court for a period of 3 months. Appeal was that was set aside. Now we are before your lordships.
The victim has filed the
appeal. So there was a scuffle for mangoes, and they are neighbors. They live in peacefully also together. You can take instructions also from the lady.
How can I take?
35 years, my lords, they are living together. And
Called upon to only assist your lordship. I cannot,
No.
because I-
Is there any material? Again, is there any material?
To some extent, it is there. Because the lordship will kindly look at my lord.
Only to some extent, na? To some extent is the acquittal. It has to be full.
That is to be examined by your lordship, my lord. The thing is that there was a conviction. In the appeal,
It's reversed.
aside on 3 grounds. One is delay in filing the complaint petition. It arises out of the complaint petition. Delay in filing the complaint petition. What is the delay? 1 day delay is there. Because the date of incident, thereafter, as per the prosecution case, the matter was, the delay's meeting was convened. He did not cooperate. Therefore, on the next day, complaint petition was filed. Your lordship knows
Yes.
the Honorable Apex Court.
Delay is explained according to you. Yes.
In sexual offences cases, it has to be, the delay has to be, in normal cases, the delay and this case delay is totally different.
The second is that there are some contradictions. I'll point out the contradictions. What are the contradictions? The court below has the appellate court has taken into account for the purpose of disbelieving the case of the prosecution. So it's a minor contradictions which doesn't carry any importance for the purpose of discarrying the entire prosecution case. The decision of University knows there are many decisions. I have also brought one decision.
What is the third one? Third one?
Third one is enmity. Enmity is a double-edged weapon, merely because there is an enmity, it cannot be, prosecution cannot be thrown away.
But you are in touch with the accused.
Yes, fellow.
Then why don't you tell the accused that
She can swear an
no.
Can swear
Simple.
Yes.
He can tell the accused that he'll persuade his client means the complainant. Complainant. Send a message so that he will give the number. He will make a statement. Withdraw the appeal. Finish it up. Why unnecessary getting into all these things?
I'll do that.
Thursday. Thursday. Affidavit is not required. You tell the accused to contact the complainant because it is arising out of a complaint case itself.
Complaint.
And he has challenged. He will withdraw the appeal. As simple as that. Unnecessary.
And it's a compoundable case. 354.
It's compoundable.
354.
Both can file an affidavit.
We can do it. Thursday?
The next week, Malats.
Let it remain in the
Yes,
weekly
let it
list.
remain on
We'll do
board.
it.
I'll mention.
Okay.
Oblige.
And since Mr. Mishra's job is made easy, since your job has been made easy by the senior counsel, you will be entrusted with some other job. One minute.
Item 46.
46. Let's see 46.
80 years, 45 years, 61 years. 506, 3 months, 100 rupees.
Yes.
And undergone both first to nil and
46. I am appointing you. 46. 46. 46 लिख दो. Mr. Prasanna. No, maybe it's for the 10th last date of 46. ठीक. Pen drive it take the paper कुछ नहीं. Just see paper नहीं.
Maybe court. Next week.
Yes. Commissioner is permitted to obtain the soft copy of the entire TCR. Yes. Yes.
93.
93. Yes. You are there in 93.
Yes.
93.
Yes, it was fine. 447, 351, 292, 323, 325, 307, 506.
Yes.
Sole accused.
Yes.
And he has been convicted under section 325 only.
325. Yes.
1 year. And so far as
Undergone period?
undergone from I think about 2 months, 10 days.
Sentence is
1 year.
1 year. 2 months, 10 days.
Yes.
My parent is like that, no? The doctor.
Yes. Yes. Are you aiming at an acquittal or why undergone? PO I'll give.
PO, yes.
PO you will get benefit.
Yes.
Undergone, I'll
He
give
has
PO.
already suffered 19 years agony.
So that I'll give PO so that section 12
Yes.
benefit also you'll get.
Yes, yes, yes.
Undergone period how much you said? And what is the undergone period you said?
2 months, 10 days.
2 months,
10 days.
10 days. Undergone.
To be precise, arrested on 6/2/2008.
6/2/2008. Yes.
And released on bail 16/4/2008. From the order sheet, reference is order number 3 and 13.
I go with. I'm not few. That's better. Few. No. Okay. Yes.
Item 34. 34.
Right, Vigilance. Here, by the appellants, they have challenged the order of conviction and sentence passed by the Law and Trial Court in convicting them for the offences punishable under sections 498A and 304B of the Indian Penal Code. Though charge was originally framed with section 4 of DP Act, they have been acquitted from the charge.
Partly you argued, no? Partly.
My lord,
4 you have been acquitted.
Yes, my lord. 498 304B conviction.
Yes.
My lord, here to substantiate the allegation, the prosecution has examined around 17 witnesses. Out of the witnesses examined, important witnesses, my lord, what I have understood, PW 5, 7, and 8.
Yes.
Along with PW 17, who is the my lord,
And the conviction is based on a particular
yes,
letter.
my lord,
A
yes,
letter
I'm
written in Bengali. That is what.
My lord, Exhibit 5 is a document which has been produced by the father of the deceased. PW5 at the stage of deposing during trial, my lord. And that Exhibit 5, though PW5 is the informant in the present case, that he had not mentioned anything about the fact that he had received a letter 7 to 8 days prior to the occurrence from his daughter, which he has produced now under Exhibit 5 original letter.
But he says that Xerox copy had given to the investigating officer.
But in the affair, my lord, true it is. I was going through some judicial pronouncement of the subject. True it is, my lord, affair is not an encyclopedia of the entire case. Most of the decisions are on the point that it is there, it is to be lost to set the law into motion. But it has been held in off-courted judgment in AIR 1975, Supreme Court 1026, Ramakrishna Pandey versus State of Maharashtra, where it has been held omissions of important facts in the affair is relevant under Section 11 of the Evidence Act. And that judgment of Hon'Ble Apex Court has also been taken note of by our High Court in 1986 CLR Criminal, page 84 and 107.
But see, if you see the FIR, although there is no reference to Exhibit 5, but contents of Exhibit 5 appears to be there in the sense it says that ଅତ୍ୟାଚାର କରି 20,000 ଟଙ୍କା ମୋ ଠାରୁ ଆଣିବା ପାଇଁ ପଠେଇଲେ କିନ୍ତୁ
I have received a letter from my daughter.
That is not there.
That is not there. And that is not there. That was also not in the statement of PW7, who is the brother of the deceased, and PW8, who is the uncle of the deceased. It was not there.
Okay.
So initially, this document was not there. My submission is to bring the same within the ambit of 113B. This has been introduced at a later stage, because IO says, PW17 says, during investigation, it was not given. Exhibit 6 was given. Exhibit 6, I mean to say the Xerox copy of the letter was given. And that has not been sent to the handwriting expert for examination.
Whether it is Xerox copy.
There is a Xerox copy.
Yes.
And it has been, this original has been given at the stage of trial. And PW7 has came, PW7, who is known, not, well, no other than the brother of the deceased, he says,
You could have moved an application before the trial court saying that send it to.
because it was not there, it has not seen the light of the day.
And it without objection it has gone into account.
It has been accepted without objection. But question has been put to PW5.
Yes, that's there.
My lord, yes. My lord, may see page 61.
Yes. The police did not.
The police did not write any Jimanama in respect of Exhibit 5. So it has not seen the light of the day. It is not a fact that I have not mentioned in my FIR regarding Exhibit 5, nor I have stated before the police regarding Exhibit 5. So he is lying there here also in material particulars. It is not a fact that the in-laws of my daughter did not demand Godrej Almira dressing table and 20,000 and I deposed falsehood. It is not a fact that my daughter did not give me Exhibit 5 and that Exhibit 5 is not scribed by my daughter, which is a false document.
Yes.
My lord.
No, the question,
my lord. My submission for my lord is Exhibit 5 is definitely an important document in the absence of any evidence to the effect that there was any demand prior to the marriage. This demand has been introduced after the marriage because PW5 has candidly said there was no demand during marriage. So after the marriage, this demand has been made. Maybe, my lord, of 6 months prior to the occurrence, this 20,000 demand. But to bring under the ambit and scope of 113B, because out of 4 criteria, last criteria is torture for given manner as soon as, not before, just before the occurrence. This has been brought to. And PW7 has candidly said, I have not stated so during investigation. My lord may see PW7.
Yes.
Sorry, yes, PW7. I was examined by the police after 1 month of the occurrence. It is a fact that I did not state before the police that my sister was ill-treated for 20,000 and that my sister sent Exhibit 5. A very categorical term he has stated. And another relative witness, the maternal uncle, PW8, he has also stated, in the chief he has stated about this 20,000, this Exhibit 5 also, my niece Lakshmipriya sent Exhibit 5 to my sister. My niece Lakshmipriya revealed from before her marriage, so and so.
Yes.
He has stated in cross, my house is for the first time Lakshmipriya came to her parents' house after 5 to 7 days of the marriage. Marriage is 1.5 years old. By that time, I had not gone to the house of my sister. About 20 days prior to the date of occurrence, I had gone to the house of my sister. I heard about Exhibit 5 from my brother-in-law and sister. I did not go to the house of the accused persons after receipt of the complaint of the letter. I was examined by the police. It is not a fact that I did not state before the police that there was a mark of the neck, so and so. And she had given a letter to my sister and brother-in-law.
But this part of the evidence,
my lord,
demand of dowry,
my lord,
is not accepted by the trial court. So
Yes.
therefore, you have been acquitted under Section 4. What will be the consequence?
Yes, what will be the
Section
consequence?
4 goes,
That
whether
answer-
498A
My lord, I'm
survives.
coming to that. I'm coming to that. Answer has been given by the Honorable
That's the real issue.
My lord. Yes, that I was coming to that matter.
Yes.
The answer has been given in 2017, volume 1, SSC, once.
In the absence of 498A,
Madam.
Section 4, only 304B.
Section 4. With regards to Section 4,
yes,
I'm reading the relevant manner.
This is actually 304 is a dowry death, basically.
Madam.
The dowry part goes, then what remains?
Madam. Madam, that has been stated in this judgment.
Which para?
But I'm coming to. Let me see paragraph 24.
24. Yes,
Where
304B is reproduced, 498 is
defined.
25. Comes
Yes,
to 25.
paragraph 27, let me see. The expression dowry is ordained to have the same meaning as section 2 of the Dowry Prohibition Act. The expression cruelty as so and so. My lord, paragraph 29 is important.
No, read para 28 also.
Yes.
Section 113B.
The enjoys a statutory presumption as to dowry death in the following terms.
Yes.
When the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death, such woman has been subjected by such person to cruelty or harassment for or in connection with any demand for dowry, the courts have presumed that such person had caused the dowry death. Explanation. For the purpose of this section, dowry death shall have the same meaning as section 304B of the Penal Code. Noticeably, this presumption as well is founded on the proof of cruelty or harassment of the woman, dead or in connection
with demand of dowry. That's what I'm saying.
Dowry, but that is the
yes.
If
you are out from section 4, in the absence of an appeal by the state.
That has been held, that has been observed by this honorable, by the Apex Court.
Yes.
By dowry, by the person charged with the offense. The presumption as to dowry death thus would get activated only upon the proof of the fact the deceased lady had been subjected to cruelty or harassment for or in connection with any
or in connection with the dowry, demand of dowry.
Yes.
By the accused. And that too a reasonable
continuity of death. Such a proof is thus the legislatively mandated prerequisites to invoke the otherwise statutorily ordained presumption of commission of the offense of dowry death by the person charged therewith. Again, my lord, in paragraph 30, a conjoint reading of these three provisions thus predicate that the burden of prosecution to unassailably substantiate the ingredients of the two offenses by direct and convincing evidence so as to avail the presumption engrafted in 130B of the Act against the accused. Proof of cruelty or harassment by the husband or his relative or the person charged is thus the sine qua non, non to sine qua non to inspirit this statutory presumption, to draw the presumption charged within the coils thereof. If the prosecution fails to demonstrate by cogent, coherent, persuasive evidence to prove such, the person accused of either of the averments or offences cannot be held guilty by taking refuse only the presumption to cover up the shortfall in proof. This line has also been another judgment matter. It has also been dealt in this way.
Para 35, read this, very important. Para 35. Read para 35. Read it.
A cumulative consideration of the overall evidence of the facet of dowry leaves us unconvinced about the truthfulness of the charge.
See, dowry, facet of dowry. Okay, next thing. Leave us to.
That I have prepared a short note, I have also stated.
Yes.
The predicament of the prosecution is compounded further by its failure to prove the precise cause of death of the deceased. It is
this paragraph 35, read it.
The prosecution in our estimate has failed to prove this indispensable component of the two offences beyond reasonable doubt. The factum of unnatural death.
This is important. The factum of unnatural death.
And that too within 7 years of marriage. Therefore, is thus ipso facto not sufficient to bring.
Ipso facto not sufficient to charge as a 498 and 498 against them. Unless dowry is.
Here, Bernard.
It is the 304 and 498 is contingent upon the dowry evidence of dowry.
And without any sort of explanation or any finding, and trial court suddenly reached a conclusion. Section 4 is.
That goes in your favor.
That goes in my favor.
They have not challenged that.
That has also been taken note of. In another judgment in SCC, 2024 INSC.
Yes.
Here, my lord, it has also been categorically stated defining section 2 of Dowry Prohibition Act and containing the evidence placed before us in the case at hand is not sufficient to prove the fourth ingredient, that is cruelty or harassment in connection with the demand for dowry, as laid down by the above mentioned case. In Rajendra Singh's case, he has Honorable Apex Court has quoted. Here I was drawing my lord's attention to Vaidyanath and others.
Yeah, this is the Vedana.
Another judgment, my lord, is Rajendra Singh versus State.
Yes.
My lord,
Yes.
here, my lord, they have Honorable Apex Court was pleased to define the Dowry Prohibition Act. That is Chabi Karmakar. Chabi Karmakar. That judgment is Chabi Karmakar.
No, Chabi.
That are yes, that is equal. Matter citation is parallel citation is 2025 1 CC 98.
Yes. This the fourth ingredient. The evidence placed before us in this case is not sufficient
Definition of
to
dowry.
prove the fourth ingredient. Cruelty or the harassment in connection with the demand of dowry as laid down here. So the cruelty should be in connection with demand of dowry. If the demand of dowry is not accepted by the trial court by equating section 4 DP Act, then 498 you can't sustain 490. The 498 you can't sustain. Then 113B of the Evidence Act, the presumption, cannot be read against the appellant. Hence 304B goes.
Apex Court has taken reliance on Rajendra Singh versus State of Punjab, 2015 106 SCC page 477.
Here they've converted to 306.
And 306 here no charge.
Court said.
I've said that. I've seen that. 306 here no charge.
This judgment also.
Yes. Here there been a conviction. They have set aside the conviction of regards to 4 DPX. But here our conviction was not there under section 4. And 306 no charge is there.
You have been convicted. You are not convicted. 306.
No, 306 no charge is there.
That's right. No problem. You have been convicted of 498 and 304B only and 34.
To convict under 306, the presumption under 130.
That's right. That is what the Chabi says. Chabi says. Yes. Anything else? Yes. What do you say?
Before that, my lord, I pray before my lordship. There is the fourth provision. That is the 4 DP Act, 498, 304 and 103 also. May I read on that part? First of all, we did the 4 DP Act.
The 4 DP Act he has been acquitted.
Yes, no, that part, that's why I am reading that. Why that the 4 acquitted in the 4 DP Act. That's why I am reading that part. If any person demands directly or indirectly from the parent or other relative or guardian of a bride or a bridegroom, as the case may be, any dowry, he shall be punishable with imprisonment for a term which shall be less than 6 months, but which may be extended 2 years, and with fine which may be extended to 10,000 rupees, provided that court may be for adequate and special reason to be mentioned in the judgment imposed sentence substantial.
Yes.
May I read, my lord? Definition of dowry, that is the section 2. In this act, dowry means any property or valuable security given or agreed to given either directly or indirectly, A, by one party to a marriage. This is the important method. To the other party to the marriage, or by the parents of either party to a marriage, or by any other person to either party to the marriage or to any other person at or before in connection with the such and such.
Yes.
It marriage is there, my lord. Why the
So what is your proposition?
because of that before marriage there is no such demand.
Section 4, the court has acquitted.
Yes, madam.
Then
On that ground, that my learned senior submission that though there are 4 DP Act is gone, and all these things are gone. That's why I am saying before there are 4 DP.
it doesn't go.
4 different ones. That don't do.
Then why have you not challenged that?
Because of my
You
lord.
could have filed an appeal against that. In his appeal, I can't take a view otherwise.
No, I am not standing the 4 DP Act. Before marriage, any transaction has been made. That if that will come under the 4 DP Act.
And
So
after marriage, no.
If there is that demand is the after marriage, that's why there 4 DP Act is not come. But the marriage word is there.
Yes. Let us see section 2.
Definition of dowry.
Let us see. Yes.
In this act, dowry means any property or valuable security given or agreed to be given either directly or indirectly, A, by one party to a marriage to the other parties to the marriage, or by the parents of either party to a marriage, or by any other person to either party to the marriage or to any other persons.
Next read.
Yes.
At or before. Or any time after the marriage.
After the marriage. That is the inserted on 86, 1911-86 with effect from. That the 3 substitute.
Included 1985. Included. 1985. When the offense is taken place?
That is 2001.
When the offense is taken place? Then you may be correct if this part is not inserted subsequently. It is inserted in 1985, 2/10/1985.
My lord.
After marriage, the demand of dowry is also included as a dowry. And for that, section 4.
Or any time after the marriage.
After the marriage. It covers after marriage, before marriage, both. And the court doesn't believe after marriage there is any demand. And therefore, section
dowry
4,
or mahar in the case of person to whom Muslim personal law is.
Don't go further. This is what you are.
No.
Meher is not included. That's what
Meher and the Muslim.
It's not a case of meher.
Not included. That part.
Not a case of meher.
So there at the time of the marriage there is no such.
Your point is correct. If there would not have been an amendment, the amendment covers after marriage situation also.
And my lord, then if the Miller, my lordship has glanced to 490.
Yes.
Whoever being a husband or the relative of the husband of a woman subject such woman to cruelty shall be punished with imprisonment for a term which may be extended over 3 years and shall also liable to fine. For the purpose of this section, cruelty means any willful conduct which is such a nature is likely to drive the woman to commit suicide or to cause a grievous injury or danger to life, limbs or health of the woman. For instance, that suicide is there. Harassment of the woman, where such harassment is within the view to the
within a view to coerce.
course
her or
any
relative
person
to
related
meet
to her
unlawful demand of dowry.
unlawful demand of
That is not believed. So you 498A, if at all you can bring, it is only explanation A. Explanation A is not your case, prosecution case.
that cruelty is there.
Cruelty for what? Cruelty forcing her to commit suicide. Is that your charge? So explanation A goes. Explanation B goes because there is no dowry. So 498 goes.
No, my
If 498 goes, 304B goes. This is the change.
That's why I'm harassment of the woman, B, my lord, may I read B? Harassment of the woman, where such harassment is with a view to forcing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on the account of failure by her or any person related to her to meet such demand.
That demand part is not believed by the trial court. Therefore, section 4 acquitted.
That part, my lord, the 4DP Act is
Yes.
acquitted.
Yes. Section 4 again you come to section 4. Your argument would have been succeeded if there would not have been an amendment to the definition of dowry. That is amended in 1995. Penalty for demand of dowry.
My lord.
If any person demands directly or indirectly from parents or other relatives or guardian of the bride or bridegroom, as the case may be, by any dowry, he shall be punished with imprisonment for a term which may be not less than so and so. So this is having acquitted in this part.
4DP Act is acquitted.
4DP Act goes. So then, therefore, what he is trying to say is, therefore, explanation B goes with 4.
Yes.
Because explanation B to 498A and section 4 needs same evidence.
Yes.
If 4 goes, explanation B goes. Then what you are left with? Explanation A. For the purpose of explanation A, you need to have a charge or allegation that he committed suicide.
Yes,
you perpetuated cruelty to force him to commit suicide. That is explanation A. That is not the case of the prosecution. Case of the prosecution is demand of dowry leading to cruelty and the death which is unnatural, therefore 304B. The genesis of everything is relatable to the dowry. All the 3 charges. If you acquit in section 4
of the DP Act,
the entire genesis is collapsed. So 498 goes, 304 goes. That is the whole case. Well, how will you answer it?
Yes, that part.
The other day it was argued extensively. He was supposed to give some judgment. That is the reason I kept it. Now he came armed with 2 judgments. I think we'll put in and you file a written note of it.
Yes, my lord. This is the one.
With some judgment. Your argument, that argument you understand.
No, my lord. Apart from that, the Honorable Apex Court held that that's right.
Yes.
That is the 91 SCC 371.
Yes.
Paragraph 3, my lord. My lord.
Yes.
Mr. Sachin, Learned Counsel for the appellant submit that there is no direct evidence.
Paragraph 3, you read?
3, my lord, yes.
Yes.
Mr. Swanson, Learned Counsel for the appellant submit that there is no direct evidence in this case and that all the ingredients of the offense under section 304B IPs are not made out. Accordingly to him, it is not a conclusive proof that the 2 appellants subject to the deceased to the cruelty or harassment, and the very fact that the High Court has acquitted
the appellant for the offense under 498A itself indicates that the prosecution is regarding the cruelty is not accepted.
And
consequently, the death cannot be a dowry
death on merit. He submitted that the absence of clear proof of the case of death on cannot be presumed that. That section 304 deal with the where the death of the woman is caused by the born or bodily injury or occurs otherwise, then under normal circumstances within 7 years of the marriage, and it is shown that soon before her death she was subject to cruelty or harassment by her husband or any relative of her husband for or in connection with any demand of dowry, such death shall be called dowry death, and such husband or relative shall be deemed to have caused her death. Explanation: for the purpose of this section such and such. However, committed dowry death shall be punishable with imprisonment for term which shall not be less than such and such. This section was inserted by the Dowry Prohibition Act 1986 with a view to combat the increase in the means of dowry dealt. It is laid down that where the death of the woman is caused by any born or bodily injury or occur otherwise than under normal circumstances within 7 years of the marriage, and it is shown that soon before the death of the woman she was subject to the cruelty or harassment by her husband or his relation or in connection with any demand
and in connection with any demand of dowry.
Or in connection with any demand for dowry, such death shall be called a dowry death, and the husband or relative shall be deemed to have caused her death and shall be punishable with imprisonment for a minimum 7 years, but which may be extended for life imprisonment. As per the expansion of this section, the dowry for the purpose of this section shall be the same meaning in section 2 of the Dowry Prohibition Act, which defines dowry as follows. Definition 2, what I am reading on that. Yes. At or before any time of marriage and such, keeping in view the object, new section such and such 113B was introduced in the Evidence Act to raise a presumption as to dowry death. It is read as the 113B is presumption is my lord. When the question is whether a person has committed the dowry death of a woman, and it is shown that soon before her death such woman had been subjected by such person to cruelty or harassment. My lord, the cruelty is there and harassment is there. For or in connection with their demand for dowry, the court shall presume that such person had caused the dowry death. Explanation: for the purpose of this section, dowry death shall be have same meaning in the 304 of Indian Penal Code. On another provision which the relative context of 498A IPC, whoever being a husband of or a relative of the husband or woman subject to such woman to cruelty shall be punishable imprisonment for term which may be extended 3 years such and such. Expansion: for the purpose of this section, cruelty means any willful conduct.
Come to para 6.
Yes, Miller. Then
come to para 6.
Para 6. Now we start.
In this case, what had happened is he was acquitted under 498A. So therefore, the argument was, since he has been acquitted under 498A, 304B will not survive. So that in that context it was said.
Yes,
read it.
Now we shall consider the question as to whether the acquittal of the appellant of the offence punishable under section 498A make any difference. The submission of the learned counsel is that the acquittal of under section 498A IPC would lead to the effect that the cruelty on the part of the accused is not established. We see no force in this submission. The High Court only held that section 304 and section 498 IPC are mutually exclusive, and that when once the cruelty invested in section 498 IPC culminate in dowry death of the victim, section 304B alone is attracted, and in that view of the matter, the appellants were acquitted under section 498 IPC. It can therefore be seen that the High Court did not hold that the prosecution has not established a cruelty on the part of the appellant, but on the other hand, the High Court considered the entire evidence and held that the element of cruelty, which is also an essential of section 304 of the IPC, has been established. Therefore, the mere acquittal of the appellant under section 498 IPC in these circumstances make no difference for the purpose of his case. However, we want to point out that this view of the High Court is not correct, and section 304B and 498 cannot be held to be mutually exclusive. These provisions deal with two distinct offences. It is true that cruelty is a common essential to both these sections, and that has to be proved. The expansion to section 498 give a meaning of cruelty. In section 304, there is no such explanation about the meaning of cruelty, but having regard to the common background to these offences, we have to take that the meaning of cruelty or harassment will be the same as we find in the expansion of the 498A, under which cruelty is itself amount to an offence and punishable. under section 303B, as already noted, it is the dowry death that is the punishable, and such death should have occurred within the 7 years of the marriage. No such period is mentioned in the section 498A, and the husband or his relative would be liable to be subject to the woman of cruelty. That 498A, there is no such period. Any time after the marriage. Further, it is must also borne to mind that a person charged and acquitted under section 304 can be convicted under section 498A without charge being there. If such case is made out. But from the point of view of practice and procedure, and to avoid the technical defect is necessary in the such case from the frame of charge under both the section, and if the case is established, they can convict under both the section, but no separate section need to be awarded on section 498 in view of the substance and such and such. There is also
Mr. Dhar, this judgment takes a different view. It says the dowry death is ingrained in the provision itself, insofar as 304B is concerned. But the cruelty is in by way of an explanation it is provided. But the cruelty word occurs in the provision itself, 498 provision itself. Therefore, it says that the two offences are in exclusive and independent offences. Even if 498 is acquitted, you can't get the benefit.
But I am not disputing that 498 and 304B, but with regards to 4 of DPI, 498 my lord can acquit me under section 304B, but can convict me under 498A for cruelty, but not for demand of dowry.
Okay.
That is just two separate things, my lord. That has been taken note of in paragraph 24 in this Vajra's case.
Is that is that?
My lord.
What he says is, under the aid of this judgment, even if this judgment is accepted on facts of this case, he says that at best you can convict me under 498A, not 304B. Because for the purpose of 304B conviction, 4 is essential, not 498.
130B.
4 is essential because it says, and this judgment supports that in the sense, it says that it is a dowry death. If a dowry goes, even if there is a death, unnatural death, 304B will not.
Convicted for cruelty.
At best, you can convict me on 498. You can convict it, no problem. But 304B goes. You file a written note.
Husband or relative of husband of a woman subject
that is the debatable question also by lordship.
That is how the law develops. You have to answer it.
Or
you have to answer it.
Yes.
You answer it. See, this is if you can really get an answer, you mention it. I'll again this, no problem. But as of today, what he has submitted, he supported with 2 judgments. It appears that if 4 goes, 304 goes.
It may be taken as
498 is made out.
It may be taken as.
And your judgment, 498 is made out. Cruelty. Even if cruelty is there, in the absence of dowry, 304B goes. For the purpose of 304B, cruelty is not required. Dowry is required.
Dowry.
With the judgment which you are citing,
yes,
it is a 498. Supreme Court is rightly saying that it is an exclusive 2 different offences. You find out some. I am reserving and judgment. You find written note of submission.
And so far another part that my senior is arguing that the executive 5 that letter.
Oh, that
part is not, and another thing
that appreciation of evidence. That is on.
And FIR in the FIR melody that
you have already argue. I noted it.
They are saying that
underline it. 20,000
या मध्यरे मो नहीं ता पूर्वरु अछि या मध्यरे मोर कन्या को विभिन्न प्रकार दैहिक निर्यातना सासु ससुर तथा तार स्वामी दियर देई आसुथिबार मो कन्या ठारू मु सुनिछि
एथि में तो 498
सेटा I'm not disputing his argument.
एथि में तो 498
he is taking this fact in a criminal case. This assumes greater importance. But if I draw my lord's attention, I've just said 75 Supreme Court 1026. Ramkrishna Pandey was state. There, my lord, case has been ended in acquittal by Honorable Apex Court. Because in the affair, name of 2 accused persons were not there. though that was stated by all the eyewitnesses to occurrence, but affair it was not there at the very first instance. But one of the leading cases. I'm just drawing my attention to that because it's an off-quoted judgment, and Honorable Justice B.K. Behera was citing it very often.
Okay.
My lord, 75 Supreme Court, 1026, when I'm just trying.
What hakim bhi eto punishment ke liye 4 ta ko chhad degi.
ये भूल करे. There, says all judgment I just that has been taken note of by Honorable Justice B.K. Behera, where paragraph 8
Then
has been quoted.
paragraph 8, huh?
8 of the judgment by Honorable Justice
Yes.
B.K. Behera and Justice U. Patnaik.
Yes.
Honorable Apex Court was also pleased to observe like this manner.
A first information to it is a previous statement which can strictly speaking is only used for corroboration and contradictions. But the omission of an important fact affects the probability of the cases are relevant under Section 11 of Evidence Act in judging a veracity of the prosecution case. The principle laid down herein are applicable in the facts of the case before us. The non-mentioning of the firing of a gunshot by an appellant, Brundavan, and the assault on the chest of the deceased by means of a farsa by the appellant Siddharth, and even about the presence of the appellant Siddharth in the first information report would not only affect the evidence of PW1, but would affect the veracity of the prosecution case insofar as these appellants are concerned. So the very vital thing is not mentioned in the FIR.
But let me see this Mr. Pandey, which has been taken very often taken note of, still holds the field. Paragraph 8 to 12 and 18.
Paragraph
8, 9, 10, 11, 12, and 18. In paragraph 18, I'm just drawing.
The dying declaration is not mentioned in the FIR, so therefore it is essential.
Mention Joginder Singh, who tried to prove the dying declaration only as an eyewitness.
Yes. Regarding dying declaration, it is not mentioned in the, so dying declaration is doubtful. That's what.
Here, Exhibit 5.
Yes.
Last page.
And in the
you file a written note of submission.
Yes.
Develop it if you can.
And in the judgment, paragraph 5 also, that the 113B, the presumption is come out on that basis.
You just because he says 498A, the cruelty, dowry is there, the element of dowry is there. But once you frame a charge under Section 4 and acquit him, then dowry part goes. Dowry part goes. If dowry part goes, then dowry death, how will you bring dowry death? That's what
that's why that presumption part is there. In the paragraph 5.
Presumption, if dowry is there, then not presumption. Because dowry, the offense is very small offense there. Unnatural death should be there, that dowry should be there. And judgment which you cite, there cruelty was there. Cruelty is not very sine qua non for yes. File written note, we'll see. Huh? Yes. And you also prepare a written note.
I've already prepared.
You highlight that legal issue so that I can answer that legal issue.
Prepared in this line.
Legal issue, if you highlight.
Yes, I have framed it.
And the question of law, highlight and.
Right.
Now, after what argument has been developed, taking into consideration.
I was expecting that, but in that line. Well, I have stated about the charge framed and points involved in the case. Nothing has been stated about Exhibit 5 in the affair.
That's the one appreciation of
my lord, appreciation. Again, my lord, with regards to construction of Section 2, presumption under 113B, referring the language of Bajanath. And also, I have not given the judgment, I will also give Shindo versus State of Punjab, 2011, volume 11, SCC 517.
Yes.
And Rajiv Kumar versus State of Haryana, 2013, volume 16, SCC 640. On the same point. I'll give the on everything.
No, he has cited a judgment. You want to deal
Yes,
with?
yes, I will also deal with.
Deal with and then so that will
I
be.
prepared it. For that reason, I have just prepared the sketch.
But he has cited a
After
very
reading and,
very good judgment there.
I will
That
prepare.
judgment is very helpful. Deal with that judgment also.
Man.
And you, if you want to cite any judgment, give it.
I will answer.
I want to verify if that.
Verify if
four-
you adding
four is
some,
go, yes,
if you
madam.
are adding something, you please give so that he will deal with that.
Yes.
Okay. Okay.
It requires.
Yes.
I don't get this. For you? Another battery is there. Next item 498A304B.
7 years.
By 34 read with 4 TPX.
Let it remain. Let it remain.
Yes.
Let it remain in the board. Yes. Next. Anybody is ready?
छोटा 324.
छोटा कौन है देखो छोटा जो था ये देखो
60. 60. Which is yours?
Lordship, 68 item number. Your Lordship, I don't have the copy of the main petition.
What is the offense?
Your offense is Lordship under 27 of NDPS.
10 gram ganja. 10 gram ganja.
10 gram ganja, Your Lordship.
10 gram ganja.
Period under one nil, 6 months to 200.
6 months, Your Lordship, 2000 rupees
6 months, 2000.
Oh, the-
Your Lordship, I'll come up with the written note of submission and make the argument.
Read 10 gram of ganja if you.
I understand.
What is the undergone period?
Undergone period.
Nil. Okay. Very small quantity.
10 ग्राम
Your Lordship, Thursday, Your Lordship, I'll finish it up. I'll come up with the short argument, Your Lordship. Finish it up.
If you can read from here, we can do it now. If you can. If you are,
Lordship.
no, you want to prepare something, then that's a different story.
Pets. For Thursday, Your Lordship.
Okay. Thursday.
Great.
Thursday, you in the first hour you come. Small matter why you took.
Yes,
it.
Your
First hour you come and do it.
Great, great.
Yes. Yes, madam.
62.
Yes.
1 year 5 minutes. 363.
363. Yes.
1 year 5 minutes. 101 days. 101.
Yes.
Present.
Yes. Ready with written note? Have you prepare written note? You should prepare a written note, it will be easier for you.
बहुत किसी लिस्ट रहुची किंतु जेहेतु अन्य माने रहुनांती सेटा को यदि
Now, I expect that the youngsters, when
Yes,
the
that's
youngster
right.
comes,
That's
you
why I'm saying-
come with a written note, that will be easier. For you also it is better.
That's
Because in the process of preparing a written note, you come across some judgment or something. So that is how you start learning things.
କିଛି କେସ୍ ଅଛି ସେମାନେ ମାନେ ଆଗରୁ ଯୋଉମାନେ ଆଡଭୋକେଟ୍ ଥିଲେ ସେ ନାହାନ୍ତି ତେଣୁ ୟଙ୍ଗ ଇଏ ତାଙ୍କୁ
Yes,
ହେଇଗଲେ
these
so that
people should-
ସେମାନେ
And I tell you, the youngsters are doing better than seniors.
today morning
Yes, they argued very well.
yes, very
Put all the point.
Already ordered 1 days.
But she wants to argue. Let her argue.
yes, yes.
Let her argue. Will you prepare a written note of submission?
I will prepare, madam.
You prepare, read the evidences and all. If you think that it's the case of acquittal, you must argue.
Yes.
Okay. Let her prepare it. Please. And Thursday, first hour,
Yes.
not after lunch, before lunch. She will also argue, will also argue in the morning. Okay. Yes, anybody is there? Yes.
Item 42.
42. Yes.
The offenses are 324 and 34 of I.
You have prepared written note. Why not?
I will.
From your office, always written notes are prepared. Senior counsel is preparing. Why are you not preparing?
Thursday.
Thursday, first half. You also prepare a written note and come. Let them prepare. Youngsters should prepare.
So
Yes,
that they can
any
come.
mentioning is there? Yes. 50. Item 50.
Yes, Sir Lordship, item 50.
Yes. What do you want?
Your Lordship, this is a matter where the prosecution has been challenge the present appeal is directed against the judgment of the conviction and order of sentence dated 31/8/2005 by the additional sessions judge, and the whereby the appellants have been convicted under section 323-34 of IPC and sentenced to undergo RI for 1 year each. And since the prosecution was unable to prove their case under sections 341, 307, and 34 of the IPC, the learned judge was of the opinion that the prosecution has able to prove the case under 323 and 34 of the IPC, Your Lordship.
Then
Your Lordship, I pray that they were in uh, they have been arrested since 18/2/2004, and they are on bail.
for 16 days. Yes. Yes.
Yes, Your Lordship, I pray that they may be acquitted under section 4 of the PO probation of the
Section 4, how will I acquit? You come, Thursday you come and argue in the court.
Yes, Your Lordship.
First hour you should come. You have put forth the point,
Yes,
but
Your
come and tell me the evidence, whatever is there.
Yes, Your Lordship.
First hour at 10:30 you should come in the court.
Yes, Your Lordship. I'll be there.
Okay.
Item 54.
What he says is 323 conviction, 1 year sentence. Is already undergone about 16 days or something. So she says give provision of offender sex benefit. She is not able to tell. Let her come. Let her come. At least something she will prepare and come.
Yes.
Yes.
Item 54.
Okay.
3,000.
Huh?
324, only 3,000.
Only 3,000. Fine.
The trial was conducted on 307, but the trial concluded with
Yes.
conviction 1 year.
No, conviction 1 year. Sentence is 1 year.
320 converted 324 and
No, it's the sentence is
Only fine.
only fine. Pay fine of rupees 300 default to undergo RI for 6 months.
Yeah.
Fine amount is released. Yes.
During trial here, I am for the petitioner.
I am amicus.
You didn't come, so I have appointed him. So I will grant, what do you say? 3,000.
3,000.
Only 3,000.
You might have spent more in the filing appeal and all. Is there any chance of acquittal?
My lord, there is also a chance because that is also the injury that has been honorable trial court has held that the injury that is that has been proven, and but that is simple in nature.
So therefore 323.
That's why 323. But so far as the occurrence is concerned, that has been proved.
Okay. For 25 years.
Honor simple in nature.
Honor
simple in nature.
I'll grant PO what to do. But for sentence, can a default sentence be covered by provision?
Because only
This is a
fine is
question. See, if his substantive sentence is there, then you will be released under PO.
But here
if there is only fine,
then how can?
Can section 4 covers that situation?
I think
Provision of
they can.
No, it can be given. 4 can be given. But it doesn't say that sentence. It says that one can be, once he is convicted, he can be let off under section 4. He can be let off under section 4. Section 4 benefit can be given. This you put that. I'll record your presence also, but since I have appointed him, I make it quick. Then now. Where is that order? The order is not there. Make it quick wala auto कर बड़ा Print out करो.
505. 505. Fine is rupees 5.
3,000. 3,000.
3,000 already during trial he has gone 22 days custody.
22.
During trial.
Okay.
1 year and the 500 fine. And default service
22 days undergone.
During trial. 42 days, that is during trial Miller, that is at page
42
days.
Undergone. 22 days he says.
Miller?
He said 22 days.
No. At page 267.
42 days.
Yes. Nineteen 2003
Whether?
to 8
Upload in 7/7/2006 26 order.
What
Two days.
print out
Twice.
Petition lately upload करना
करना ले प्राइस.
लिस्ट फाइल पूरा लिस्ट फाइल
सब तो ये
साथ में निकला 7/7/26 चेक कर
ना ले लो. नहीं तो मैं ज्योति
फर्स्ट टाइम लेके स्कूल से
एसी की मेरे स्कूल की लिखो ना लिखो कौन लिख सकता है जो आप बोल
500 in a different model.
Who is out of them? Who is AC? Who is here? How will I know? कौन ऑर्डर थिला ऑर्डर 7/7 ऑर्डर 7/7 ऑर्डर करी अपलोड करे बाद में लोग 7/7 ऑर्डर 5 अपलोड करो दे दो 7/7
That is 55. Sorry, 55. He's in 54. I am 55. Yes, not
Same.
No. Different.
He is in 50.
All right, cut this. It is 50.
54 था सर 55 था टोटल
55 plus 54 plus 54.
This is 54 or 55.
54
File is 54.
This is Vibhuti Theory. You are appearing for Vibhuti. Tarpur order refer code.
Normal charges होती है पीछे.
22 days are already 22 days already undergone PO. ठीक है, इसको ले PO 55 कौन है ला?
55 307, but convicted under section 320. Trial was under section 327.
320?
324.
Yes.
1 year imprisonment and 505. Already has gone.
Undergone how much? 20? Undergone 42.
Undergone 42 days.
42 days.
Plus.
42 days undergone. Undergone and fine कितने वो fine
500.
so shall I PO can be given 324.
That's it.
Conviction 324 or
320.
324.
324 1 500.
324.
Right for 1 year and pay the in the disclosure.
Here also we can give PO.
Yes, sir.
Probation we can give.
Okay.
Probation we will give. PO, huh? Give the PO good. Okay, thank you.